The Honourable, the Speaker.
Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honourable members, I have received communication from Mr. Fazal Karim, MP, member for Shogunas East, who has requested leave of absence from today's sitting of the House. The leave which the member seeks is granted.
Bills brought from the Senate, petitions, papers.
The Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay the following papers. 1. The audited financial statements of MIC Institute of Technology Limited for the financial year ended September 30th, 2016. 2. The annual report of the First Citizens Bank Limited for the year ended September 30th, 2018. 12. The report of the Auditor General of the Republic of Trinidad and Tobago on the public accounts of the Republic of Trinidad and Tobago for the financial year ended September 30th, 2018. 13. The public accounts of the Republic of Trinidad and Tobago for the financial year 2018. I beg to move that paper 1 be referred to the Public Accounts Enterprises Committee and papers 12 and 13 be referred to the Public Accounts Committee.
Honourable members, the question is that paper 1 be referred to the Public Accounts Enterprises Committee and papers 12 and 13 be referred to the Public Accounts Committee. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I have the honor to lay the following papers. Paper number 3, the ministerial response of the Ministry of Finance to the 12th report of the Public Administration and Appropriations Committee on an examination into the administration of disaster relief in Trinidad and Tobago. Paper number 4, the ministerial response of the Ministry of Health to the 13th report of the Public Administration and Appropriations Committee on an examination into the administration of special healthcare programs in Trinidad and Tobago. Papers 5 and 6, the responses to the 10th report of the Joint Select Committee on Human Rights, Equality and Diversity on the treatment of detainees at the Immigration Detention Center. The responses are from the Ministry of National Security and the Ministry of the Attorney General and Legal Affairs. Papers 7 to 10, the responses to the 20th report of the Public Accounts Committee on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2017. The responses are from the Ministry of Energy and Energy Industries, the Ministry of Foreign and CARICOM Affairs, the Ministry of Education, and the Ministry of Social Development and Family Services. Thank you very kindly, Madam Speaker.
Prime Minister.
Madam Speaker, on behalf of the Prime Minister, I have the honor to lay paper number 11, the administrative report of the Office of the Prime Minister for the period October 1st, 2016 to September 30th, 2017.
Reports from committees.
Member for Caroni East.
Thank you, Madam Speaker. Madam Speaker, I have the honor to present the 18th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Caroline 1975 Limited for the years ended 30th June 2010 to 2018.
Member for Kamuta Mansinilla.
Thank you, Madam Speaker. I have the honor to present the 8th report of the Joint Select Committee on Social Services and Public Administration on its first follow-up inquiry into the current level of violence among students in schools with particular focus on physical and cyberbullying.
Member for Kamuta Mansinilla.
Thank you, Madam Speaker. I have the honor to present the 9th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the state of contract employment in the public service. Thank you.
Prime Minister's questions, urgent questions.
Member for Princess Town.
Thank you, Madam Speaker. Madam Speaker, question 1 to the Minister of Education. In light of the water woes affecting the constituency of Princestown and several schools being dismissed early due to a lack of water, could the Minister indicate what contingency plans are in place to avoid this disruption due to dry taps in Princestown?
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, no school in the Southeastern District has been dismissed early. We have made arrangements with WASA and the fire services to prioritize a supply of water to schools who may be affected. Schools have also been requested to put measures in place to monitor and conserve water. Let me repeat, no school in the Southeastern District has been closed because of lack of water. Thank you very much.
Member for Princess Town.
Thank you, Madam Speaker. Is the Honourable Minister saying that he is not aware that Princestown Presbyterian No. 1 and Princestown Presbyterian No. 2 schools have been disrupted due to a lack of water? Is the Minister categorically
Minister of Education.
That
Member for Princess Town, you have already asked the question. Minister of Education.
Madam Speaker, just before I came to this chamber, I was in contact with our Director of School Supervision, who was in contact with the line School Supervisor 3 for the Southeastern District, and the information that was relayed to her indicated that no school has been closed. Thank you very much.
Supplemental Member for Princess Town.
Madam, clearly that the Minister is not aware of what is happening in the schools.
Order, order. Member for Princess Town.
Thank you.
Maybe member for Diego Martin North East and member for Caroni East. Maybe you all are not looking this way. Member for Princess Town, you're allowed to ask a question.
Thank you, Madam. Madam, in light of the answer provided by the Minister, saying that he is not aware of what is happening in the nation's schools, could the Minister categorically deny that Princestown Presbyterian No. 1 and Princestown Presbyterian No. 2, their classes have not been disrupted for this week due to water problems?
I'm not going to allow that question. I believe that question has been member for Princess Town. Member for Princess Town. Member for Princess Town. Member for Princess Town, I am warning you that you are offending the standing orders. Would you get up, retract what you have ever done, and we can press on?
Madam, I retract, but I stand as a representative.
Member for Princess Town on.
And they are with thousands of them are without water. We have been denied to speak on their behalf in this parliament.
Member for Cuba South. Member for Princess Town, I've cautioned you on more than one occasion. Your behavior is in breach of standing order. I consider it gross disorder, and I ask you to withdraw from the chamber for the balance of today.
Thank you, madam, but it doesn't change that Princestown has no water. It does not help
Marshall.
Princestown. It does not
Marshall.
help people of Maruga Tableland. We are being stifled in
Member for Princestown.
To be the voice of the people, madam. And that is totally unfair.
Please leave.
Madam, it will not
Member for Princestown. Marshall.
People do not have water. They do not have water. We are the elected representatives who should be allowed to speak in parliament. We have thousands of people who cannot get water. A basic human right.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you very kindly, Madam. Madam Speaker, there are 3 questions for oral answer. We will be answering. Madam?
Member for Couva South. Member for Couva South. This is the last time I'll stand to warn you. This type of behavior is not going to be tolerated today. All members will be advised to comply with Standing Order 53. Leader of the House.
Thank you very kindly, Madam. Madam, there are 3 questions for oral response today. We will be answering 2 of those 3 questions, and we are kindly asking for a deferral of question number 170 for 2 weeks. Thank you very kindly. There are no questions for written answer.
Number 170 is deferred. I now call on member for Urupuch West.
Thank you, Madam Speaker. Question number 168 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, there is absolutely no correlation or relationship between the government of Trinidad and Tobago's principled position of non-intervention and non-interference in the affairs of other sovereign countries and the issue of Venezuelan nationals illegally entering Trinidad and Tobago. To suggest this, as the question implies, is a continuation of the UNC opposition's use of misinformation from the Cambridge Analytica playbook. The UNC's strategy of continuously repeating falsehoods, twisting the truth, no matter how ridiculous their utterances are, is extremely dangerous. Madam Speaker, the reality is that other countries that border or are in close proximity to Venezuela, for example, Colombia, who have taken a different position with respect to the internal governance of Venezuela, face the same issues with Venezuelans entering their country illegally. They actually, in Colombia, have over 1.5 million people from Venezuela entered, and not all of them have entered legally. Once again, for the record, the Trinidad and Tobago Defense Force, and in particular, Madam Speaker, the Trinidad and Tobago Coast Guard has been dedicating resources to border patrol, both maritime and land patrols, in an effort to prevent illegal entry into Trinidad and Tobago. They have been assisted by the Trinidad and Tobago Police Service, Immigration, and our intelligence services. The use of all of the serviceable Coast Guard vessels to perform maritime border patrols aimed at preventing illegal entry into Trinidad and Tobago, as well as requesting similar activity by the Venezuelan authorities, are examples of the operational measures that have been in place for the past few months. The government will continue to use all available resources to treat with this problem in a proactive and purposeful manner. And we take this opportunity, Madam Speaker, to thank the men and women in the Defense Force, the Police Service, Immigration, Intelligence, and all of those others who are manning the borders in order to protect us from illegal immigrants.
Supplemental member for Urupuch West.
Thank you. Honourable Minister, how is your announced registration process going to affect the countermeasures that you have just highlighted here in relation to deterring illegal Venezuelans?
I will not allow that as a supplemental question. Member for Urupuch East.
Thank you very much, Minister. And thank you for indicating that we are not as bad as Colombia. Could you indicate within the last 2 days or so, given the very recent volatile situation in Venezuela, what steps would have been taken to increase patrols and patrols on land and to protect that part of our border?
Minister of National Security.
Thank you very much, Madam Speaker and Member for Urupuch East. Madam Speaker, as I said, over the past few months, efforts have been stepped up to prevent the entry both on the maritime as well as on the land side. Within the last 48 hours, going on to 72 hours, we have increased the number of patrols. Of course, the number of vessels we have remains the same, but we're turning them around more. I don't want to talk more about the operational side. Thank you.
Member for Urupuch West.
Thank you, Madam Speaker. Question number 169 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. The Ministry of Education does not collect data on children who display symptoms of pre-diabetes in primary and secondary schools. B, the Ministry of Education has met with and granted approval to the Diabetes Association of Trinidad and Tobago as far back as 2016 for primary and the secondary schools to participate in school quizzes, expositions, as well as art and recipe competitions. These activities focus on sensitization of students on diabetes. The ministry also collaborates with the Ministry of Health and the regional health authorities to conduct diabetes awareness sessions in primary and the secondary schools. C, the following initiatives have been undertaken to reduce the incidence of prediabetes in primary and the secondary schools. 1, through the health and the family life education, physical education, and the science curricula at the primary and the secondary schools, the areas of diet, exercise, and lifestyle diseases, including diabetes, are addressed. 2, in September 2016, the Ministry of Education, in collaboration with the Ministry of Health, has implemented a prohibition on the sale of serving of sugar-sweetened beverages and foods at school cafeteria canteens in all schools. 3, currently the ministry is also involved in the Healthy Schools Trinidad and Tobago project, again in collaboration with the Ministry of Health. The project involves A, the implementation of programs to develop and maintain adequate levels of physical fitness, promote psychomotor skill development, and the acquisition of healthy lifestyles, and B, the training and the continued professional development for teacher administrators in the area of health promotion and the physical literacy. The first phase of the project is expected to be implemented in all government and government-assisted primary and secondary schools in September 2019. Thank you.
Honourable Member for Urupuch West.
Honourable Minister, is the Ministry of Education working in a silo that you could not liaise with the Ministry of Health to get the number of students who are pre-diabetic?
Minister of Education.
Madam Speaker, throughout my answer to this question, I've been speaking to the collaboration of the Ministry of Education and the Ministry of Health, and therefore that question does not arise. Thank you very much.
Supplemental Member for Urupuch West.
Madam Speaker, Honourable Minister, the question asks, question A, the number of students, and you said that you're liaising with, I'm asking, do you have the number, yes or no?
I believe that question was answered originally.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Guyanese.
Thank you, Mr. Speaker. In accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave to move the adjournment of this House for the purpose of discussing a definite matter of urgent public importance, namely the unacceptable, unprecedented, preventable electrical blackout at San Fernando General Hospital on the 25th of April 2019, which endangered the lives of scores of patients. The matter is definite because it refers to the disruption of an essential supply of electricity for 4 hours at the San Fernando General Hospital on the 25th of April 2019. The matter is urgent, Madam Speaker, because there is a necessity for immediate repair intervention in order to prevent a recurrence of this event in the near future, as this had directly imperiled the lives of scores of patients on critical life support ventilators, both adults and neonates, and patients in operating theaters having surgical procedures performed. The matter is of public importance because the San Fernando General Hospital serves hundreds of thousands of citizens in south and central of the country, and its proper functioning is of major importance to all these citizens. Thank you, Madam Speaker.
Honorable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursues this matter under Standing Order 16.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Combat Corruption and Other Wrongdoings by Encouraging and Facilitating Disclosures of Improper Conduct in the Public and Private Sector to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith be now read a second time. Madam Speaker, Trinidad and Tobago is wrestling with its conscience and is fighting for its salvation. This country has engaged in an exercise which, in many senses and according to many commentators, is the equivalent of the definition of insanity. It has been engaged in the management of the #1 issue plaguing citizens, that is crime, by simply doing the same thing the same way every time and expecting a different result. In this regard, Madam Speaker, it is clear that improving the number of years and enlarging the number of years for which an offense is to be treated with in court, raising the fines and adding structures along that route simply don't take us anywhere. The country has not been focusing, Madam Speaker, upon the most critical of issues, and that is evidence. We talk in this country about Mr. Big or Mr. Small facing the courts of Trinidad and Tobago. People ask, where is justice? People believe that justice is skewed. But it is one thing to have information. It is one thing to banter about allegations on a day-by-day basis about corruption or wrongdoing or criminality. But information is not intelligence, and intelligence is not evidence. The only place that one can have a conviction materialize in the sanctity of the courts where due process prospers is with intelligence moving on the back of information into the realm of evidence. And this law, Madam Speaker, this bill constituting a campaign promise of this government is one of the most essential tools to take us to this particular route of making sure that evidence and quality evidence results in convictions. Now, Madam Speaker, we have spent the better part of our time in this Parliament engaged in the reform of the criminal justice system, birthing of courts, introduction of rules, appointment of more judges, declogging and management of the processes inside of the courts. We have spent a second round of our time improving the white-collar crimes, of making sure that money laundering is a crime which is triable either way, of ensuring that preliminary inquiries are to be abolished, of making sure counsel of choice is instead replaced by counsel of competence, in making sure the system works in an efficient way. But there are two essential pieces of law that really bring the quality of evidence forward. One is before the Senate as we speak. Those are the evidence amendments in the Evidence Amendment Bill. And the second one is this particular piece of law. This law sits atop the Civil Asset Explain Your Wealth legislation. It is directly rooted to it. It sits on top of the disclosure of beneficial ownership in the Companies Amendment Bill, now Act. It sits atop the amendments to cause the creation of a beneficial ownership registry. It sits atop the Registration of Deeds Amendment Bill, which is in this House for debate. And the purpose of this bill, as the long title suggests, is an act to combat corruption and other wrongdoings. By what? By encouraging and facilitating disclosures of improper conduct in both the public and private sector. And what is it engendered and engaged to do? It is to protect the people who make the disclosures from detrimental action as is defined under the Act, and to regulate the process in which this must work. The bill itself, Madam Speaker, is divided into 4 parts and is 29 clauses long, and we'll get to that in a second. But the bill has some history. This bill was, in its original form, laid into this Parliament on November 13th, 2015. It was accompanied by a statement which I delivered then on behalf of the government, and the bill was referred to a Joint Select Committee. We went into a Joint Select Committee, and that committee held 12 meetings in the period December 4th, 2016 to July 15th, 2016. And in those 12 meetings, we considered a wide matrix of stakeholder comments. We received fulsome commentary from the public and appointed stakeholders, and the committee comprising members of the Senate and members of the House went to work on ensuring that we could get a bill together. The original bill as laid did not have a 3/5 majority. In the course of the committee's work, we considered, pursuant to advice received, that the bill ought to have a 3/5 majority, and we did that, Madam Speaker, on the back of the fact that the bill does certainly, in its form now before us, intersect upon certain entrenched rights in both Sections 4 and Section 5 of the Constitution. So let's get that out of the way immediately. Section 4A, B, and C of the Constitution, Section 5, 2, E, and F provide as follows. 4A is the protection of the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. 4B, the right of the individual to equality before the law and to protection of the law. 4C, the right of the individual to respect his private and family life. 5.2e, you shall not deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of his rights and obligations. And H, you shall not deprive a person of the right to such procedural provisions as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. How does that relate to us today? This bill, in defining who is a whistleblower, what is to be protected in the mechanism of whistleblowing as a protected disclosure, how it is to be treated, what immunity is to be offered to that whistleblower, what is to be denied to the people who would otherwise have rights of action against the whistleblower, those 5 aspects intrude upon sections 4A, B, and C, and section 5.2, 8, E, and H as I've defined. How so? Number 1, the employee, as defined, and I'll come to that in a moment, has the right to use information which may include confidential information and to deliver it to whistleblowing reporters, either in an internal process or external process. This also has the opportunity to ensure that the whistleblower is not prosecuted by offering civil and criminal immunity and immunity from other detrimental action, including administrative and industrial relations and general employee-employer type consequences. And therefore, the employer is going to be denied an opportunity covered by Section 5 of the Constitution. So in denying that, in causing an exception to the laws of secrecy, in causing an exception to the Data Protection Act, in causing an exception to other laws of our country, the Integrity in Public Life Act, in some circumstances, there is a definite intrusion of rights. But let's deal now with the concept of Section 13 of the Constitution. Section 13 of the Constitution permits an abrogation of rights defined in the Constitution, provided it is such that it is supported, firstly, by a 3/5 majority, and secondly, that it is proportionate in a democracy such as Trinidad and Tobago, which recognizes principles. So what are the legitimate aims which deal with the 3-pronged principles of legitimacy and proportionality in law? As per Maraj, as per Surat, as per Francis, as per any one of the umpteen judgments in our jurisdiction, biting both from the Privy Council level and our Court of Appeal level. They provide the need for a legitimate aim, that there's a rational connection of the legislation to that aim, and thirdly, that you go so far as you need to and no more, or that you are within the boundaries of existing law known to your country. That's essentially what proportionality means. In this particular context, what we can say by way of proportionality is that this law did not appear out of the blue. Very importantly, Madam Speaker, and for the record in dealing with proportionality, we looked at and we borrowed from legislation including the following jurisdictions: the United Kingdom in the UK Public Interest Disclosure Act 1998, Malaysia in the Malaysia Whistleblower Protection Act 2010, Jamaica in the Jamaica Protected Disclosures Act 2011. We also looked, Madam Speaker, at the laws in Malta, the Malta Protection of Whistleblower Act 2013. We looked further, Madam Speaker, at the laws in several other Commonwealth jurisdictions. We looked at Canada's Public Service Disclosure Protection Act. We looked then, Madam Speaker, at a number of jurisdictions and states in the United States of America, etc. And all of these laws borrow from a similar vein of legitimate aim in targeting the protection of whistleblowers from detrimental action if they are proper disclosures relating to the proper type of material, they are done in good faith, they are not false, there must be a mechanism of system. So we borrow immediately in terms of legitimacy and proportionality from the several jurisdictions that I have just mentioned, Madam Speaker. But Madam Speaker, if we stick a pin for a moment and go to legitimate aim some further, we have a Proceeds of Crime Act. Our Proceeds of Crime Act deals with, for instance, in sections 44 and 45 of that act, the concept of money laundering. Money laundering is the obtaining of profit or money out of criminal conduct from specified offenses that are defined in section 2 of the Proceeds of Crime Act and set out in the second schedule of the Proceeds of Crime Act. And that includes a host of matters: taxation, kidnapping, murder, trafficking in persons, etc. A number of matters which we are now well familiar with. But when we look, Madam Speaker, to the statistics of proceeds of crime, and we disaggregate them year by year in the period 2013 to 2019, and we look at corruption, bribery, money laundering, and we look at the data on arrested people versus convictions, Madam Speaker, We look at obtaining goods, money by false pretenses. We look at fraud. We look at conspiracy to obtain money by false pretenses, etc. If we look at fraud alone, 2012 to 2018, 2012, look at the numbers just from the judiciary, magistracy, 965. Next year, 1908. Next year, 3821. Next year, 3457. Next year, 3175. Next year, 2650. That's for fraud alone, the number of cases, statistics produced by the judiciary at the magistracy. We have similarly for the High Court level, but when we get to the Trinidad and Tobago Police Service, and you look at the data which the government obtained in its police manpower audit through the auspices of the British High Commission, and very importantly, the data which came through the Attorney General's office when we did a prosecutorial audit to see what was going from information to charge to conviction, suffice it to say, the base of information by way of reports is in the thousands, and the numbers that hit the court are in the hundreds. And then you get to single digits when you get to the Court of Appeal. Why? Because matters have not proceeded because witnesses can't be found. Witnesses can't be found because they're frustrated by preliminary inquiries. Preliminary inquiries run to a term of 20 years in this jurisdiction, plus they are frustrated by intimidation. They are frustrated by threats of murder, assault. They are dealt with, Madam Speaker, by difficulties surrounding the personalities that must manage the information, corruption inside the respective services, laissez-faire, lack of training or competence. And so, Madam Speaker, the government's target via the Evidence Amendment Bill and via the Whistle Protection Bill is to encourage whistleblowers to step forward. Why? The common law right now recognizes the concept of indemnification, both in the criminal and civil law. You can be indemnified as a whistleblower by the state, quite properly, protected, enter under plea bargaining and other arrangements, pursuant to what? Pursuant to the criminal law. In fact, the case is AG's reference number 2. And umpteen state witnesses have gone through that way. I give you the case of Levi Morris, for instance. I give you the case of Abdul Malik, the Parmesa, forgive me. Parmesa, state witnesses turning as they did under the cooperation of the Director of Public Prosecutions taking a particular course of action. In the civil law, there is also the concept of indemnification, both at state level and at private level. And therefore, in these circumstances, our current law recognizes the ability to clothe whistleblowers with protection. But that is very onerous. That is very cumbersome. So we have grounded it instead into an existing bill which proposes this. So let's come back on track now. In the Joint Select Committee, I have to confess that it was a serious Joint Select Committee, but it was a serious Joint Select Committee which involved a complete divergence of views. And I make no bones about saying this, Madam Speaker. There was a particular senator on the opposition bench who, despite any advance by the government, simply refused to support a single aspect of the bill. I'll be charitable. There was a divergence of view. The particular line coming from the opposition on the Senate end was, we want a consolidated piece of law. We want to reform the law to replicate what the Integrity Commission looks like. We want a centralized service. This bill proposes a decentralized system for whistleblowing. Why? Because it proposes to treat with whistleblowing in the public sector and in the private sector both. And therefore, the law is framework law, Madam Speaker, where we ask for the establishment of internal processes for whistleblowing and external processes for whistleblowing. So we've taken a hybrid approach. So let's get to the bill, where we'll flesh out a few of these provisions. Of course, the first clause is the Whistleblowing Protection Act short title. Second clause is that it shall come into operation by proclamation, the commencement. The third is that it is an act inconsistent with the Constitution and requires a special majority. The fourth clause is the definitions clause. And in it, in particular, we look to see designated authority. The designated authority as defined in this law and as set out in the schedule is a list of public entity bodies, including Integrity Commission, Office of the DPP, Ombudsman, etc. These designated bodies are the entity to which whistleblowers who are frustrated or debarred from an internal process or who don't trust an internal process, they can approach the external bodies, the state bodies. Also, the external bodies are the bodies, the designated authorities, who receive the serious matters referred to them by internal bodies, where there is evidence of a crime or an offense. Detrimental action is critical. Definition of detrimental action is to say what the employee, what the whistleblower, because the whistleblower in this act is referred to as the employee, what the whistleblower should not be subjected to. You should not be subjected to unfairly established disciplinary action. You should not have be unfairly dismissed, suspended, or demoted, harassed, intimidated, victimized, transferred against will, unfairly refused transfer, terms and conditions altered to disadvantage, adverse references, etc., etc. Importantly, you should not otherwise suffer injury, loss, or damage in relation to employment, family life, career, profession, trade, or business. It's a very wide description of what detrimental action is. It's grounded in umpteen precedents coming from the jurisdictions that I've referred to a short while ago. In particular, Jamaica was particularly persuasive. A disclosure is a disclosure by a person of information which shows improper conduct. Who is an employee? The employee is the whistleblower. And what we have sought to do in categorizing the definition of employee is to say that an employee is somebody who is engaged in contract, contract for services, contract of services. Somebody who is a volunteer, somebody who is an employee in those two categories of an agent of someone, somebody who's working part-time. In other words then, even though we've used a term which otherwise is a strict connotation of employer-employee relationship, the definition of employee as whistleblower is a wide-ranging circumstance designed to attach anybody who has access to the information in any capacity that they may have access to the information. Madam Speaker, employer is obviously the person on the other side of the employee relationship, and it is so defined. An external disclosure is defined as that which goes to the designated authorities. Now, what is improper conduct? The whistleblower must be reporting on improper conduct. And if that person is reporting on improper conduct and is doing that reporting within prescription and for bona fide purpose, that improper conduct must be a criminal offense or failure to carry out a legal obligation, conduct that is likely to result in a miscarriage of justice, conduct likely to threaten health or safety of a person, conduct likely to threaten or damage the environment, conduct that shows gross mismanagement, impropriety, or carrying it out in relation to public funds, acts of reprisal against the whistleblower, conduct that shows unfair discrimination on the basis of gender, race, place of origin, social class, color, religion, political opinion, willful concealment. What does that do? It captures existing laws. The Environmental Management Authority, it captures the OSHA legislation, it captures common law offenses, it captures the whole host of laws treating with public procurement and disposal of property. And that, therefore, makes this law a natural relative of the public procurement legislation. This law will be a natural relative of the campaign finance reform law, which we will bring to Parliament almost immediately upon Cabinet's consideration of it, if Cabinet so approves. We also then treat with the various forms of discrimination, and notice that we've added in political discrimination. Far too often we hear political parties in opposition say, it's a witch hunt, you're coming behind me, etc. That's why this goes to a court of law. It is not decided by anyone. That's why this government's approach on scandal, on mismanagement, has been a rather demure approach, Madam Speaker. We don't stand and name and shame on a daily basis. Action must speak by the authorities that engage in action. The Trinidad and Tobago Police speaks for that, not any political appointee, Madam Speaker. Madam Speaker, we then go to what an organization is. Because a whistleblower does a report on an organization. An organization includes an entity, meaning an individual, or any body of persons, etc. And that therefore takes care of incorporated, unincorporated, and also individuals in terms of who can be reported on. A protected disclosure is defined under Section 8.1, and we'll come to that. Public body, we tie it into the Public Procurement and Disposal Act, etc. And who is a whistleblower? A whistleblower means any person who makes a disclosure, not just any disclosure, it must be to a whistleblowing reporting officer, to a unit, and it must be qualified as a protected disclosure. In other words then, this is not a law. This is not a law designed to just go and tell the media. This is not a law designed to go and scandalize people's names. This is not a law designed for any of those purposes. This is a law that says if you are with information of improper conduct, you want to speak to it, engage in the reporting in the procedures prescribed by law, internally or externally, make sure that you're telling that you're making this disclosure on the basis of good faith, essentially. If you are willful in your disclosure on something that is false, you will suffer a penalty and an offense and jail term. It is designed, similar to the Integrity in Public Life Act, to condemn action of that type, Madam Speaker. And Madam Speaker, this law in Clause 5, and then when we go into Clause 7, this law is effectively retrospective. This law applies to conduct that existed prior to the commencement of the law. The general principle in law is that retrospectivity must be identified in law. I refer to Leonage and the AG Privy Council decision as the locus classicus, which has persuasive authority on us. We dealt with it in the Northern Construction Section 34 matter for the repeal of that on the issue of retrospectivity. There is nothing wrong with retrospectivity, provided that there is A, an expression that it is to be retrospective, and B, it doesn't engage in the type of odium that the court considers is there. This law describes its retrospectivity. This law will apply to a P&M government. This law coming in our 4th year in Parliament means that everything that this government has done will be subjected to this law. This law applies to persons prior to us as well. The point is that this law is not discriminatory. Had this law come in year 1, yes, okay, it could have been a political argument that we're targeting our political predecessors, but this law comes 3.5, nearly 4 years into our term, and we took that opportunity after we had put the base preparation into place, courts, systems, amendments of law, as has happened. So, Part 2 deals with disclosures of improper conduct. What is a protected disclosure set out in Clause 7? A protected disclosure is where the employee, which means whistleblower, makes a disclosure of an improper conduct to a unit, but you must have reasonable grounds to believe. It is not reasonable suspicion. It is not mere suspicion. There's an objective standard in law in the utilization of the phrase in law, reasonable grounds. The disclosure under subsection 1 may be made although the employee is not able to identify a particular person, although improper conduct occurred before the coming into force of the act, whether it was in relation to information acquired which probably should not have been disclosed, etc. If it is to be given orally, which can happen, you can actually have it reduced by way of a process. It can be given anonymously. But anonymous witness whistleblower information is not protected until the person becomes known. Why? Because the law is designed to protect you when you are known from detrimental action. And that is a critical point inside of here. It also makes sure to treat with an important observation raised by Member Ramadhar in the committee, which is where we treat with parliamentary privilege, and we have especially carved out the the manner in which we treat with Section 55 of the Constitution, which is the absolute privilege of Parliament in the context set out. And Madam Speaker, Clause 8 says when that disclosure is protected, it must be made in accordance with Section 7, i.e. you must go through the process. It must be made in good faith. It must be where the whistleblower at the time of doing it reasonably believes, based on information, that the information is substantially true, etc., which he knows or ought to know or reasonably know is not false. And therefore, this excludes out the wicked purpose. This includes, for instance, a matter which is now ended, the Dansam Dansuk kind of matter, where a fraudulent statement was engrossed into an affidavit and brought to a parliament, laid on a table, and resulted in something which happened in the courts and which then fell apart after due process. That kind of distinction, that kind of perjury will not find itself in this place. Madam Speaker, when we go to information relative to legal professional privilege, it was important, again, Member Ramadhar had significant concerns and this government had significant concerns. We treated with it in Clause 9. We get to Clause 10, here's the anonymous disclosure. And we treat with the fact that you can make an anonymous disclosure, but if that anonymous disclosure is libelous or scandalous, you're going to take note of it, you'll file it, but you won't act upon it. Why? It's reasonable to expect that in today's world of fake news, false information, robots that come and chime into your Facebook account and give you reports of everything you're doing wrong, all with the same timestamp, 50 people arriving at the same time, false information and false narratives, Cambridge Analytica style, are a feature of this world, and therefore libelous and defamatory information given anonymously does not prevail. Madam Speaker, quite interestingly, sticking a pin, at the caucus of the government in dealing with this law, we sat down as a group, and there were 3 letters provided to the government. One addressed to the Minister of National Security, one to the Minister of Housing, and one to the Attorney General. And in that, without going into the specifics, a whistleblower stepped forward anonymously and gave information in relation to fraud touching and concerning $147 million of fraudulent activity. Just like that, by pure coincidence, long before we announced this bill was going to be debated, this happened. And I'd like to say that the government has taken note of the willingness of several whistleblowers to step forward, because the Americans have a very interesting statement. The first guy on the bus gets the best seat. That's the expression in the American corruption arena. The first guy on the bus gets the best seat. And this law treats with that. Because when we get further to the whistleblowing mechanisms, and I'll come to it very quickly, you will see that this law does not exculpate an offender. An offender cannot come and hoodwink and get immunity by simply saying, I was guilty, but now I want to exculpate myself. No criminal, no civil treatment for me. I'll just clothe myself as a whistleblower and get out of Dodge. That's not how this law works. This law specifically provides for the manner in which the court ought to consider the whistleblower's evidence, and that ties in to the existing law in Trinidad and Tobago for criminal prosecution whistleblowers and for civil law whistleblowers. And that's the existing law. Division 2 sets up the method for internal disclosures. Basically, everybody in Trinidad and Tobago, public and private, have to set up internal divisions. You have to have a designation of a whistleblowing reporting officer. Is it any different from Freedom of Information Act? No. Is it any different from public procurement and disposal legislation? No. You can designate an employee. But this law provides, by the external route, where entities are just too small to do it and have not created entities. So we've catered for the fact, the argument that may come to say, look, how are people going to operationalize this? How are you going to afford a whistleblowing protection where it's a one-man show? The employee who's a gardener, for the boss who's getting contracts, knows that there's theft. How you report to the boss in a one-man show? You can do the external route disclosure. That's clauses 11, 12, 13, straight down to Division 3, where we deal with external disclosures. External disclosures are to designated authorities. Designated authorities are set out in the schedule, and they are 21 in number: Auditor General, Board of Inland Revenue, Bureau of Standards, Central Bank, Children's Authority, Customs and Excise, Elections and Boundaries, EMA, Equal Opportunities, Fair Trading, FIU, Integrity Commission, National Physical Planning Authority, OSHA, Agency and Authority, Office of Procurement Regulator, DPP, Ombudsman, RIC, TTPS, SEC. Why? How are you going to have public procurement laws? Ask for public procurement laws to go to work if you have no evidence. How are you going to get evidence if you don't have a whistleblower to tell you, look, I sat in X position and I noticed corruption in a particular place in public procurement, be it the government works, private works, a contractor side. You need to give that person the clothing of protection. And for those reasons, we've established external authorities this way. When we get, Madam Speaker, to clause 14, we say you have a director, we say what the functions are, Madam Speaker. We then get down to an employee of an organization may make an external disclosure in what circumstances. 1, if there's no internal route. 2, if you don't trust it. You didn't get a response in time. You feel the head is compromised. You feel the body is with turpitude. Then step out of that dance and go to the external unit. Don't worry with that process. Urgency of the matter, etc. Madam Speaker, clause 16 deals with reference of information. Clause 15, of course, provides the time frames. In the internal route within 30 days, in the external route within 45 days, further steps for reporting. Clause 16 says where the external unit thinks a better unit should receive it. So somebody makes a report to the ombudsman thinks, you know what, the DPP needs to see this, or the SEC needs to see this. We provide for reference forward, and we make sure in each step of referral onward, there is anonymity. You don't just automatically say, Faris Al-Rawi made a report to internal, it then went external. External number 1 says, Faris Al-Rawi made a report to external number 2 or external number 3. No, there is anonymity until there is action on the evidence, and then it is enveloped into one. Part 3, clauses 18 onward, treats with protection of whistleblowers. This is very important. You're protecting a whistleblower in clause 18 from detrimental action. We've defined detrimental action. Clause 19 is the biggie. You are protecting them from civil, criminal, disciplinary proceedings. Let me repeat that. Civil, criminal, disciplinary proceedings specifically, and all detrimental action. But there's a caveat. It must be whistleblower was in good faith. There's a perceived threat to public interest, etc., etc. We then go, no immunity to a whistleblower if he has or he was a perpetrator or an accomplice. So clause 20 treats with the person who tries to fool the system, commits the crime, and then says, I'm a whistleblower. No, sir, clause 20 treats with you, but clause 20 mitigates your circumstances by saying, you know what? Even though you were guilty, even though you participated in a crime, even though you watched the destruction of the treasury of Trinidad and Tobago, you were an accomplice, you were involved in that matter, you have now found your conscience. Your mitigation needs to be factored in a court of law. Why? That's how it's done right now. AG's reference number 2 via the DPP, civil proceedings, etc. That is where you take the advantage of someone pleading to guilt, as it's done in the United States of America, in England, in Canada, etc. That's clause 20. Madam Speaker, there's a prohibition of disclosure of information to identify a whistleblower, very strictly in clause 21. Clause 22, we provide for civil remedies for detrimental action. We say a whistleblower who believes that detrimental action is likely or about to happen, but who has not yet been under clause 18, where you're being protected once you're known, you can take anticipatory protection, go to the High Court, and get the advantage of injunctive protection by way of High Court proceedings. Because you must be kia temet, just in time. You must be anticipatory in protection, because what is the point if the baby is thrown away with the bathwater? So that's what clause 22 does. In part 4, clauses 23 to 29, Madam Speaker, these are the offenses. And listen to them, clause 23. A person commits an offense if he knowingly prevents, restrains, or restricts any person from making external or external disclosure, knowingly intimidates persons, knowingly induces persons, threatens, etc., being an employer knowingly subjects that person to detrimental action, purports to make a disclosure under this act knowing that it contains a statement that is false or misleading, or being reckless as to whether that statement is false or misleading. That comes directly out of the Integrity in Public Life Act. Why? This law is not designed to further wicked purpose. And all of us sitting in this parliament, as politicians, know what wicked purpose looks like. We're often subjected to it ourselves, but you know what? That's what we signed on for. Those of us in this dance subject ourselves to the fact that public office holds public scrutiny, and eventually your day will be had. Nobody exemplifies coming through every time a victor better than the Honorable Prime Minister, Dr. Rowley. Every time. Madam Speaker, clause 24 deals with the obligations of secrecy and confidentiality. You cannot disclose without committing an offense the person's identity. That's a serious issue. Things must be managed in a very careful way. You're treating with pre-trial prejudice. You're treating with publicity aspects. This government has subscribed to that insofar as it is very careful about criminal matters not to speak to these matters in the public domain. It may speak about civil matters. That is an entirely different purpose. Madam Speaker, there's a penalty for obstructing whistleblowing reporting personnel in clause 25, a penalty for destroying, falsifying documents in clause 26, where there's a conflict between contract of service and provisions of the Act prevails in clause 27. And again, that relates to a 3/5 majority issue as to the supremacy of the constitutional rights for protection of, for equality of treatment and for protection of property in sections 4A and sections 4B of the Constitution. We allow for the minister, subject to affirmative resolution, to amend the schedule. Let's come back to Parliament and say who ought to be there, not by negative resolution, but by way of affirmative resolution. And the minister has the power to make regulations. Why? Because the minister is creating framework legislation, and framework legislation requires prescription, and prescription is done by way of regulations. Again, the regulations are subjected to affirmative resolution of the Parliament, so that the Parliament knows what it is doing. And importantly, we cause an exception to Section 63 of the Interpretation Act, where we modify the fine away from $500 TT for breach of a regulation, and we prescribe instead penalties for offences not exceeding $50,000 and imprisonment for 2 years, keeping it sort of in tandem, albeit at a slightly lesser level, from an act of perjury for breach of an oath of secrecy. So, Madam Speaker, the government has come to this Parliament after a Joint Select Committee, which was not completed. It was not completed because it was clearly evident, at least from my capacity as the chairman, that there would be no agreement in that committee. Secondly, it was completed and then a new bill was crafted based upon the entire consultation. We came with a 3/5 majority. We came to ask the opposition for its support. We came to ask the opposition for its support in the circumstance of saying, are you prepared to encourage whistleblowing protection? Are you prepared, on behalf of the citizens of Trinidad and Tobago, to give evidence a fighting chance? Are we prepared as a parliament to combat corruption, wrongdoing? Are we prepared to breathe life into the public procurement legislation, into the Proceeds of Crime Act, into industrial relations law, into environmental protection? Are we prepared to do that? Madam Speaker, this country is on trial. This country is fighting for its soul. This country has upon it decisions to be made based upon the concept which can be put in one word: value. What is your value? What is your value system? Who are we working for? This government makes itself subjected to this law. This government, in asking for retrospectivity, says, "Come all ye who know about us and tell your story if it is a proper disclosure about improper conduct. Come and sing your soul to the correct authorities and the correct process." We say that of ourselves. We bring this law now after treating with the criminal justice system, after putting the white-collar crime principles anchored into the Civil Asset Forfeiture Explain Your Wealth legislation, Companies Amendment Act, beneficial ownership, importantly, the Registration of Deeds Bill, which will treat with the abuse of equity, which will treat with secret trusts, which will treat with where you hide your wealth lawfully. We make ourselves subject to this law. Kumuto Manzanilla might think that funny, may not subscribe to its principle. We'll hear from her. But the point is, this law, once passed, can be proclaimed with immediacy. And this law, once proclaimed with immediacy, as the Honorable Prime Minister says, every top shall stand on its bottom. So, Madam Speaker, we await the contributions of the Honorable Members opposite. Today is D-Day. Today is about whistleblowers. Today is about justice. I beg to move.
Honourable Members, I shall now propose the question for debate. The question is that a bill entitled "An Act to Combat Corruption and Other Wrongdoings by Encouraging and Facilitating Disclosures of Improper Conduct in the Public and Private Sector to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith," be now read a second time. Member for Urupuch East.
Thank you very much, Madam Speaker. Thank you for the opportunity to contribute this morning on arguably one of the most critical pieces of legislation in recent times that the government has brought before us. Madam Speaker, I was happy to hear the Attorney General, and let me say from the outset, I've been the recipient of several copies of this bill, and as I go along, I'm hoping that if there's any mistake I make in relation to the bill itself, because it has changed somewhat over the period, that the Attorney General would correct me if I make any mistake, because earlier in a version of the bill that I had, when the term minister was used, it was used in reference to the Minister of National Security.
I have that version.
Today, the Attorney General is piloting this piece of legislation. I am therefore to believe that minister means the minister, the Attorney General, or is it still the Minister of National Security? If he is not piloting the bill. It's the first query I make, but it is a simple matter. It is not a difficult matter. So the Attorney General will pilot a bill for which the minister in the bill is the Minister of National Security. That is fine. If that is the issue, it is not a problem. All I'm seeking is clarity. Madam Speaker, I sat for 45 minutes and listened to the Attorney General of this country. At no time you had cause to reprimand any member of the opposition for disturbing him. I expect the same courtesy and respect. Madam Speaker, there are several issues I'd like to raise, and just to put in a framework what I intend to do. I intend to speak to the objective and policy of the bill, the operationalization of the bill. I will raise a couple issues in terms of the legal and constitutional issues, but there are members on my side of the bench who are much more qualified to debate and argue those issues of the legal and constitutional principles. But I will touch a couple of them. But I will speak really to the objective and to the operationalization of this bill. Madam Speaker, I've had the opportunity to read this bill on about 3 occasions at different times, and the Attorney General gave us the history of it. This is not the first, I think it may be the second, but it's the second unusual situation where a matter has been referred to a joint select committee. And remarkably, the government position is that we know what you're doing in the joint select committee, so we end that. Over the years, the practice, the done thing, is that regardless of what the government and opposition may think on an issue, you will submit a completed report, and the opposition, whether it's the PNM or UNC, will bring a minority report. So that the opposition, PNM or UNC, will argue their case by way of a minority report, and the majority would have a report, a majority report. Something like that has happened over the years. But to hear today the Attorney General saying on behalf of the government is that we ended that process. We chose not to continue because we realized you're not supporting. Okay, that is highly unusual, and again, and one member, incidentally, was not giving support and so on. So, highly unusual, but we go with it again because I imagine you can do that. Madam Speaker, they're in charge, they can do that. Madam Speaker, I want to put on record that I might be the first person speaking on this bill who is actually a whistleblower. I am a whistleblower. And I want to read the definition of a whistleblower, Madam Speaker. A whistleblower is a person who exposes any kind of information or activity that is deemed illegal, unethical, or not correct within an organization that is either private or public. I am a whistleblower. And Madam Speaker, I'm in the courthouse today because I'm a whistleblower. So in a way, I have a selfish interest in this bill. Section 19 protects me. If the bill was in effect, I could have pleaded that I'm a whistleblower and you cannot sue me. So maybe now I will try to see how I can get into this institution of whistleblowing structure so that I can go to the courthouse and say I'm protected by Parliament and Section 19. Having said that, they may come with an amendment to exempt members of Parliament from that clause. But Madam Speaker, a few points in the introduction I want to make again. I'm taken aback a bit that the bill, and I've looked at the legislation in Malaysia, Canada, Jamaica, elsewhere they have quoted Malta, I believe, as well. And Malta? In Malta as well. Madam Speaker, the Attorney General says quite rightly that the bill deals with both the private and the public sector. It may have been useful, since it's the first time we are going to embark on this type of legislation, to look at the public sector, but the private sector, and I'm saying it in a policy sense, not with the legal construct, to look at the public sector in its entirety, but the private sector that connects with the public sector, clearly meaning private companies that contract, that do business with government and ministry, state enterprise, rather than the blanket private sector. Because as it is, and the Attorney General and members can correct me, it is the private sector companies, all 76,000 companies, all companies that operate. And I'll give a lot of examples because another point I make early is that this requires substantial public education. Yeah. So people understand what the government is doing and the public. Because you see, in a strange way, you may have consulted with many organizations, and I took note of it, but you really didn't consult with the whistleblowers. Because the whistleblowers are the key people here. And we have had in this country, Madam Speaker, whistleblowers from time immemorial. I want to remind the country for the record, the first prominent whistleblower in this country was Jean Miles, who in the early 60s spoke out about the gas station racket, told of underhand deals in the 60s, valued large sums of money for granting gas station. She gave evidence before a commission of inquiry in the 60s into corruption for the granting of license. She was the first. I think she went mad and died as a street dweller. I think she died as a street dweller in poverty in 1972. She was the first. But we have had a succession of whistleblowers in this country, some quite prominent. So that the issue is not that we want new whistleblowers or whistleblowing is new. It is we are creating a structure, an institution, so that you allow now for protection and filter in information that can become evidence. So that is what we are about today. Madam Speaker, let me just repeat that for the benefit of the Attorney General, that whether some type of construct could have been found to encompass the entire public service and the element of the private sector that contracts with the public service. So you protect state, you protect taxpayers' money, strictly speaking. Because what you are doing now, you are saying if somebody is running a hardware or a restaurant or something, they hire 20 people, they are under this legislation. But they are not contracting with public monies per se. If there is wrongdoing there, they have avenues that they can go to. The police, the fraud squad, and other institutions and law enforcement that they can go to. Not necessarily through a state apparatus. Because the objective here, as I understand it clearly, is you want to protect the public purse. You want to protect that. So I raise that issue. Madam Speaker, I know the time we have these days are limited. Today is one day I would have wished we had the 75 minutes for the Attorney General as well. So let's get to the bill because I want to go through some of the issues with the bill. There can be no complaint about the intention of the legislation. Protecting public disclosures, protecting persons who make disclosures on matters of corruption, wrongdoing, and so on. There could be no issue, no complaint that you are against people who do that. Because that is a very important part of governance today. That somebody who smells something, as we say, or get in their possession some document, they must get into a system that protects them so they can bring forward for investigation and any other action that may take place. Madam Speaker, the Attorney General is quite clear. He understands, I think, the society we live in. This is a society where quickly, depending on how much you imbibe, rum shop talk could become national talk. You can go in this country, and I have been a victim of that. I speak as a victim, where there's a political strategy to drown you in rumor. Yeah. What they do is there's a strategy, a political strategy. They drown you in rumor so that people believe that someone is wrong, someone is corrupt, someone is, involved in hanky-panky. And it is rumor that they drown you. And Madam Speaker, I tell you honestly, I speak as a victim of that. I speak as a victim. And the Attorney General is correct. This bill, if not properly structured, this bill could become the rumor bill to facilitate a rumor mill. This could be for every rumor around the corner. Madam Speaker, so that anybody see or suspect or smell hanky-panky, as it is, this bill is structured. And they deal with contract of services, and I'll come to employment matters in a little while. And Mr. Attorney General can correct us. Someone contracts for a service. Let's assume it's a gardener, a maid or landscaper or pool person or something comes on your property. Right? There's a contract for service. In a business, let's assume business first, organization. And they see something. They suspect something. They see some visitor, some special visitor arriving. They see a plant-like substance. They see visitor arriving. They see maybe somebody with a bag moving up and down. They say, aha, that looks suspicious, I will complain. Where is whistleblower? And if they don't have the internal mechanism, they go external. You can promote that in the society. And the landscaper or the pool person want to either protect their job or they want an increase in their pay. And you can create a situation like that. So the Attorney General knows that and has placed some type of check and balance in the bill already on that score. But I will argue in a little while that that is certainly not sufficient. Madam Speaker, I also want to build an argument as I go along that instead of protecting whistleblowers, this can expose whistleblowers to serious fines and serious prosecution. You know, the first protection you need to give against for whistleblower is try to keep them alive. But that's the first protection. If you blow the whistle on $100 million corruption, 147 million corruption and so on, those are big numbers. Those are serious numbers in a society that is plagued by crime and murder and mayhem. So, Madam Speaker, you go as a whistleblower, you have information on $100 million corruption scandal. The first challenge is to remain alive. It is not to escape civil liability. It is to escape a coffin. And if you cannot protect persons in this society from being killed, then protecting them from civil liability and so on is lesser. And that is my first deep concern. The bill becomes in effect when it's proclaimed, not when it is assented to. The member for Lavantil West appeared last week, Thursday morning, on the Facebook. And I think he was announcing from an unknown location, high up in the air, with nobody in sight, that the last civil forfeiture bill was assented to. And when somebody told him it is not in operation because it's not proclaimed, 47 minutes later the video was removed. Madam Speaker, so it's proclamation that makes this operational.
It's still there.
Madam, the video is still there. Madam Speaker, the member for Lavantil West is disturbing you.
Just don't be distracted. Please,
Thank you very much.
I just want to ask one thing. You asked for protection earlier. It applies to both sides, I guess. It applies to both sides? Okay, member for Lavantil West, please continue, sir. Continue.
Madam for Lavantil West is not speaking.
Continue.
Oh, thank you very much. Madam Speaker, I go to 4. And the bill has a very serious component, and this is why I chose to read 3 times, study, and speak, and offered myself to the Chief Whip to be available. Madam Speaker, the employment and labor relations matter involved here is very serious, because this attempt to set up structures at the place of work called organization in the bill. You see, Madam Speaker, you create designated authority. We'll come to that later. Detrimental action, I think you explained that. That is when you take action against an employee, aka a whistleblower, and so on, unfair, subject to disciplinary harassment, intimidation. I don't want to spend too much time with that. If you refuse to give a reference, you know, it is quite detailed what detrimental action is, and so on. Madam Speaker, the disclosure means disclosure by a person of information about potential improper conduct, what an employee means. Now, is there any synchronization with employee? And I'll just raise this for the purpose of clarification. An employee as opposed to a service provider who is not in the industrial relations legislation may not be considered an employee. We have enough case law to tell us about the conflict between employee and contract worker, and do they have the same rights? Is a contract worker as well also a whistleblower as opposed to an employee? Now, I assume every single public officer in the civil service is a potential whistleblower. So we know that. Madam Speaker, so the wakaman, the poolman, the landscape person, the maid, or so, becomes an employee for the purpose of this bill as a potential whistleblower. We are clear on what an employer should mean. It's not a big thing. Madam Speaker, what this bill sought to do is to establish at the place of work. Now, minister means the minister to whom responsibility for national security is assigned. Now, Madam Speaker, this is a place of work matter dealing with allegations of wrongdoing, which are not just criminal or may not even be criminal. It could be unfair practice, it could be misconduct in some other form. One is curious as to why the minister with responsibility for national security has this role in this bill as opposed to the Attorney General, strictly, who I think has some jurisdiction over matters of the Equal Opportunities Commission and other tribunals that deals with these related matters. Madam Speaker, protected disclosure we are clear on. The Attorney General at Clause 5 told us about the retroactive nature of the business and so on, so I won't want to get into that. Madam Speaker, the protected disclosures deal with improper conduct, not with criminal conduct, but improper conduct, of which criminal conduct may or may not be, because at first it is not criminal conduct. It is improper conduct. So that a disclosure made as a protected disclosure, although the person making this disclosure is not able to identify a particular person, although the improper conduct occurred before coming into force of this piece of legislation, in respect of information acquired by the employee while he was employed, he may be a former employee. So it may not be a current employee in your place of work now. It could be somebody who left the place of work. Now, if this person left the place of work under some circumstances where he was fired, where he was suspended, where something had gone wrong. I think of CPEP contractors in particular these days. They're in the courthouse these days with employees, former employees. You can become a whistleblower after you leave the place of work, because you then suddenly discover that 2 years ago I saw something, I heard something about this contractor who didn't pay my NIS. Madam Speaker, you tell your story orally or in writing. And they provide for it that you can make an oral disclosure, but you must reduce it to writing, I think within a time frame as well. Madam Speaker, the person who makes a disclosure must reduce that in writing. What I have, the disclosure made in relation to a member of parliament shall not amount to a breach of a privilege. So I think that is the issue that the member for St. Augustine raised. Madam Speaker, at clause 8, I want to get into that quickly. It deals with protected disclosures. A disclosure is a protected disclosure if it is made accordance with 7, of course. It's made in good faith, so you're not malicious. At the time of making the disclosure, the whistleblower reasonably believes, based on the information at that time, that the information disclosed and any allegation contained in it are substantially true. Madam Speaker, when people get information by nature of the people where they are in an organization, right? You are working at a computer desk in a business, you are listening to your boss, you have information that they ask you to type. Hypothetically, Madam Speaker, they ask you to type an email, and in the email some transaction is taking place. You don't know whether it's true, whether it's not. You have no basis of knowing whether it is even substantially true, but it looks suspicious. Madam Speaker, is that bar a proper bar to subject person in a protected disclosure that they must know it is substantially true, what they are saying, as opposed to knowing that it is credible? It may be true. So, Madam Speaker, this is the first one I'm making, that you are trying to protect whistleblowers, but placing this kind of onerous burden upon them, that when you come with information, you must know it is substantially true. The whistleblower has no legal training, the whistleblower has no legal assistance, the whistleblower has no financial or accounting training. How is he or she to know that the information I am telling you that looks suspicious is substantially true? Otherwise, they can face penalties, Madam Speaker. They can face penalties. The disclosure is not made for personal gain. We understand that, what that might be about. In the case of an internal disclosure, it is made substantially in accordance with internal procedures. Now, the bill speaks to establishing internal procedures for every organization. If you are dealing with 76,000 companies in the private sector, 20-something ministries of government, 100 state enterprises, is it that all of these companies will have the same procedure, a different procedure, and what procedure will they be introducing? Would it have been more useful to standardize one procedure and put it in a schedule to the bill? To say we have one procedure, anybody come, this is a simple standard procedure, follow that procedure, and get your information out. But you cannot reasonably expect that 76,000 companies and 500 state enterprises will come up with their own internal procedures to receive whistleblowers. So that is the first serious matter. Madam Speaker, disclosure is not protected if the whistleblower discloses information which he knows or ought reasonably to have known is false. The Attorney General touched that because he was clear on that. Again, Madam Speaker, you are asking whistleblowers to indicate that you should know that, ought reasonably to have known that the information is false. Now again, I give you real-life examples because those of us in the business of politics for many years, like journalists, people come to us with all kinds of information. Madam Speaker, people come with information on every single person in the world. And I'm sure my colleagues opposite, they receive their information as well. And when you ask the person, did you see this? No, but the neighbor's son, daughter-in-law, tell me. Then you ask somebody, is it, do you have a copy of a tape or a video of something? No, but there's a person who have it, but I'm not seeing him until next week. And then you quickly have to realize that, and at the end of the meeting, you can help me with a little money. So you understand what's going on in Trinidad and Tobago. So one has to be very cautious on this matter, because if someone I'm informing members of the national community, if you think you are a whistleblower and have information to share on bubble, and and you come to this through this mechanism, and it is proven that you ought reasonably to have known it is false. And again, Madam Speaker, I choose to do this because there's a time when I must speak as well. A member of this government went in 2015 on a political platform, would you believe, and asked me if I know about a mall in Holland. Yes. You know that? A member of the government sitting down here. 4 years now, they can't find big mall, they can't find small mall, they can't find... And they will search. I wish you could give me a ticket to go and look for it myself. I wish you could give me a ticket to go and look. I would love to go and look. If you give me that. Madam Speaker, Lavantel West is saying I should be careful in the airport. I come into that just now. Madam Speaker, a member of the government, would you believe a senior politician office holder asking me that? I say, go and find it. 4 years now, you can't find it. But this is Trinidad and Tobago. Should I ask the person if he what? I would ask the person, you ought reasonably to have known it is false. But you commit an offense. Madam Speaker, that offense is fine and jail. So let me indicate that. Madam Speaker, information protected by legal professional privilege. There are some legal issues there, which I would leave to other colleagues. We have something on that. Anonymous made, okay. The anonymous disclosure is not protected until the veil is removed. There's some debate about that because, an anonymous information is also critical information. But the Attorney General, I think, explained that somewhat. I don't want to debate that particularly. He says when you become known, then you get the coverage. So that's fine. Madam Speaker, I want to move on to 10. An employer shall appoint... Now, listen to this. Listen to this, I will say it only once. An employer shall appoint and keep in his employees such whistleblowing reporting officers that are required. How much whistleblowing reporting officers that are required? 1, 5, 10? They are saying appoint. That is a job you are creating. It is not from the workers who are the field now on the shop floor. So 50,000, 76,000 companies are appointing one or more whistleblowing officers. What's the qualification for that? So the employer is appointing a man or woman as a whistleblowing officer, and that person one day have to tell the employer, boss, I need some time off to go to the whistleblowing unit to report you. That is what happened here. This needs proper thinking, Madam Speaker. The employer cannot appoint a whistleblowing officer who will go and has the potential to destroy your business because they can take complaint and so on. Clearly, this cannot work. And appoint on what basis, on what qualification? Then what happens in a company, a private family company? The family company says, we hire here 50 people. Call one relative, what you doing? I doing nothing. Use the whistleblowing officer here. Come, I have a job for you. Because there's no qualification attached. Now, government will say, we're bringing that by regulations. That is dangerous what they're doing here. They are trying to pass a majority bill and then do everything with simple majority with regulations. Good point. That's what's happening here. So this cannot work. Madam Speaker, I have also been involved in trade union work for years and years and years, Madam Speaker. When the employer has this power to appoint someone as a whistleblowing reporting officer, who will the employer appoint? Someone who is a serial complainant? In the place of work, people talk all the time. They say, see this person? That person always complaining about everything. Every time they come with something, they're talking about corruption and bubble and things. What do you do? Appoint that as a whistleblowing officer? And you have to pay. Who paying this whistleblowing officer? Is it another cost for the company? Clearly it is. The government, I don't think, going to be paying the whistleblower. What is the terms and how much money per month? OJT 5,000, 10,000, 8,000. What's the terms and conditions of the whistleblowing officer? And they have responsibility. Hear this. The person being appointed has responsibility for receiving and processing internal disclosures of information about improper conduct at the organization, determining whether an internal disclosure should be referred to any further authority, Whistleblowing Reporting Authority. That's the power. Although the complainant or the whistleblower can go behind your back and do an external, look at what happened here. The whistleblowing officer, who is appointed by the employer, will get the knowledge first. You know, John Doe come in here to report about something he see in the back of the hardware or in the back of the company. He come in to complain. I told him that don't have no relevance, man. That is not true. And you know, you're going to Port of Spain to deal with the DPP office. The employer has knowledge of that. So this is a recipe for victimization and discrimination at the place of work. The way it is currently structured, Madam Speaker. I mean, I want to tell you, my friends opposite in your own language. Somebody working in Balize House as the tea lady or janitor sees two ministers talking in the back, innocently exchanging, you know, a bag with some, you know, food or something. You know, I say, look, I saw that. But if I go, I can't report to first, Senator Cummins, the General Secretary, going by the DPP. You understand what is happening here? You cannot set up like this. It has to be some type of structure that allows for independent persons. At least, Madam Speaker, in the trade union community, the shop floor representative, Mr. Kuva South, is appointed by the workers. The workers in a place of work, they vote for their shop steward representative. He or she represent the workers and take up their matter. The employees are not voting for their whistleblower or officer. It is appointed by the employer. That is fundamentally flawed and has to change. And you know, Madam Speaker, I want to tell you something. Let's assume that you get a good and proper whistleblower officer. A man or woman of integrity, character, strength, courage. I'm hoping we'll find that. You know, Madam Speaker, I want to quickly drift to 24.1 in the bill. Do you know the penalty, and I hope I'm reading it wrong because I don't have the latest version. The penalty of any persons for who disclose then, or who leak, to use the language, identity of a person making disclosure and so on, and statement, give no documents, anything like documents and identity. Do you know the penalty there, Madam Speaker, is $600,000 and 2 years in jail? Now, who is going in this world to be a whistleblowing officer who, if somehow, somewhere, your employer or any other co-worker comes with a complaint that they can fabricate some evidence against you, that you leak the identity of the person making the complaint, the whistleblower himself or herself, you face a penalty in law of $600,000. Yeah.
Your original speaking time is now spent. You're entitled to 15 more minutes.
Thank you.
You may proceed.
Thank you, ma'am. You face that penalty, Madam Speaker. You cannot subject a whistleblower to a fine of $600,000 and 2 years in jail on this. Now, I know there must be a penalty, but that penalty has to be a bit lighter, I believe, so that persons are encouraged to do the work. And, Madam Speaker, a person as a whistleblowing officer is a person who so far is doing this job, I think, might be free. Or a salary, we don't know. That person may be getting a little chichi at the end of the month as a whistleblowing officer. But you have to pay $600,000 if it is deemed that you leak information on identity or documents, and 2 years in jail. That has to be looked at, Madam Speaker. Come on, man. I mean, sorry, that has to be looked at. Madam Speaker, you have now to publish, employer shall publish and republish widely in his organization at regular intervals the internal procedure. So, of course, on the notice board, you put an internal procedure up. Madam Speaker, the date of time, 30 days, the whistleblower and reporting officer collects information. He has 30 days to notify the person making the complaint of the status of the matter, if he has referred it, if it has been dealt with, and so on and so on. Madam Speaker, I want to get some critical matters because I won't have time to go in detail on everything I wish to. Remind persons that the whistleblowing officer so far has no qualifications that are being put in the law. So it could really be anyone with any qualifications to do serious work of collecting information, having suspicions whether this could be true or not, taking it to a whistleblowing reporting unit in a designated authority. That's the job. Madam Speaker, let me get to this whistleblowing reporting unit now. And I'll set it out quickly because I don't want to spend too much time. What they're doing is they have selected 21 agencies and institutions, Madam Speaker. Madam Speaker, I'm very concerned the Parliament of the Republic of Trinidad and Tobago is not a designated authority. Maybe it should. But Madam Speaker, 21 authorities designated, all will have a whistleblowing reporting unit. Who appoints this unit? Who appoints the director? On what terms and conditions? Is it that the Minister of National Security appoints whistleblowing units or approve terms and conditions? Who will really appoint whistleblowing units in 21 agencies of government, Madam Speaker?
Integrity Commission as well.
And those persons, we have no idea of what is the qualification of a director. What is the qualification? Is he a lawyer, a police officer, someone trained in law, someone involved in, before in some matters related, Madam Speaker? But they are going to give jobs to these persons, and these persons collecting information. So you have here a non-police investigative unit. Madam Speaker, that speaks to another danger. Yeah. Where you have persons who are not police officers specifically, well, not even with legal training in some cases, undertaking investigations at first hand into serious concerns. Now, when you deal with whistleblowing around the world, I keep saying, this is not just for a pan of paint, somebody thief a pan of paint somewhere, and you report, somebody going home with a wheelbarrow. This is for hundreds and millions of dollars. Think of fake oil. Think of these land deals that they have been talking about as well. Think of all those things. Think of matters like that, buying a boat, buying aeroplane. Yeah. Madam Speaker, this is what it concerns. And you have persons that the law will not tell us their qualifications. Madam Speaker, another matter that I want to raise quickly is the matter of penalty. Now, it is clear in the legislation, Madam Speaker, that there are serious penalties for persons who induce, threaten, make promise. I'm looking for the exact clause, Madam Speaker, because I want to be moving quickly and not in the order I proposed earlier because of the time. 23. Is it at 23? I'm being told. So let's jump there. At 23, Madam Speaker, if you prevent, restrain, restrict any person from making a disclosure, you intimidate, you make a promise or a threat to someone that they ought not to make a disclosure, you are committing a serious offense, Madam Speaker, and I believe it is $15,000 and 10 years in jail. So if you promise someone, so in the bill as it's set up with an employee-employer relationship, if you fail to promote someone, and that has to do with telling the person not to report a matter, you commit an offense, 10 years in jail. If you promote someone, you commit an offense and it's 10 years in jail. Because both can be found to be inducement. But Madam Speaker, I want the Attorney General to consider a serious matter now. Consider what is not raised here. What happens when someone induces a whistleblower to give a statement? By monetary payment, by promotion, by some other form of inducement to cause someone to become a whistleblower. Yeah. You see, hypothetically, Madam Speaker, someone may need money, and you could give someone $10 million. 15? You could give someone $15 million, and if that person is terminally ill and needs money immediately, they can become a witness. They can become a whistleblower. So you can get money, you can get payment, and then in another part of the law, you can get immunity from prosecution and become a witness. And in this case, become a whistleblower. So, Madam Speaker, I'm asking the Attorney General to prevent that. To prevent persons to create now another offense, that anyone who induce by promise, by threat, monetary or otherwise, promise, and pay money for someone to become a whistleblower in these circumstances, commit an offense and is subjected to a fine and a heavy term of imprisonment. Because, Madam Speaker, it will be a travesty of justice if we create a whistleblowing organizational structure where persons can induce people to become whistleblowers with cash, with promises, with contracts. So you owe somebody money, and the person say, the government, hypothetically, the government, because the public service we're dealing with, the government owes someone money, and you say, listen, we're ready to pay you. We are paying you X millions of dollars, but you have to do something. And you become a whistleblower. That is an offense, and it must be placed under this specific legislation. And worse, Madam Speaker, if it is in circumstances where people are ill, terminally ill and dying, and require cash, Madam Speaker, for their health, that should be a higher penalty. Madam Speaker, so Madam Speaker, I raise that issue because in Trinidad, in this culture we run here, which we are all aware of, many of us in public life for years now, we are aware here, governments, business persons, private and public, governments owe business persons a lot of money. They owe. And when it's time for payment, you can induce, you could seek to induce, to threaten persons to become whistleblowers under this legislation. So we must now create that offense. If it's the only thing we are adding into this bill, that anyone found guilty, conspiring or otherwise, to induce whistleblowing activities should be punished with fine and jail. Madam Speaker, the structure. Now, I know that they consulted and so on, Madam Speaker. And Madam Speaker, we have to protect persons. I will just touch very briefly on the two matters. Madam Speaker, I have in my possession, I think it is part of the documents of Parliament, an opinion given by Ian McIntyre, Senior Counsel, Chief Parliamentary Counsel, in which in a startling revelation, Madam Speaker, I can't read the whole thing before you, but I have it here. I think it is part of the record. Indicated that this bill not only violates fundamental and constitutional rights, for which you can come, for some of that you can come with a simple majority, but it goes so far in the violation of constitutional rights that a court, Madam Speaker, a court of law can rule that this bill fails the proportionality test and is not reasonably justifiable in a democratic society. And that is a serious alarm that comes not from the UNC, not from the opposition member, but from the Chief Parliamentary Counsel, that even if you pass this bill with the requisite constitutional majority, you can still fail. Madam Speaker, the Attorney General tells me it's the old bill. I will leave that to a new Speaker. Madam Speaker, I want, Madam Speaker, to indicate that the structure that they are putting in place from an employment perspective cannot be operationalized, and cannot be operationalized soon. What you should reconsider is a simpler structure that keeps whistleblowing protecting units alive in a lesser number of agencies, but allow workers or citizens to access them quickly. That is all you need. You didn't need to go to 76,000 employers and tell them hire somebody and pay the money for it. You don't need 21 departments of government putting a unit in place to pay. Now they call this person a director. When you say director, that means M-O-N-E-Y. That's not an OJT person. You're going to spend enormous money on this when you could simplify that structure and allow persons to come with their information or complaints, protect them in terms of the disclosure, and if they bring material that has truth in it, the whistleblowing protection unit can take the matter further. And I recommend as well to the Attorney General that we try in this process in Parliament, we try to simplify the structure that you are putting in place. And you may be able to do it quickly if you try that, Madam Speaker. Madam Speaker, we have had evidence of whistleblowing in this country in the recent past. And I just want to remind persons, Carrie-Ann Moray, employee of the Ministry of Sports, blow the whistle on somebody. Charmaine Lewis was fired as General Manager of the Port Authority in 2017 after she testified before a JSC, Madam Speaker, on the procurement and maintenance of ferries for the Inter-Island service. Ronald Ford was fired as General Manager of PTSC, and Mr. Ford said something in the newspaper that is so, you know, the Attorney General said this deals with the soul of the country. Here the soul of Mr. Ford. He said, he warned people when they go before a JSC, you cannot be factual or truthful, otherwise you will end up on the breadline. Could you imagine a general manager of a state enterprise tell the country, don't like me, don't tell the truth before a JFC, you could be on the breadline. Mr. Attorney General, this is the soul of the nation we're talking about. when a public officer like this speaks in that language in the press. He was not the protection of Parliament, he spoke in the press. Madam Speaker, Leon Grant was fired as Chief Executive Officer of the Inter-Island Transport Company in 2018 after he contradicted evidence given by a member of Parliament on that committee. He gave evidence that was contrary to a high-ranking member of this government. Madam Speaker, Harry Raghunandan was thrown out of the People's National Movement, and he was thrown out of everything when he raised issues of procurement process and worthiness of the Cabo Star Ocean Flower Galleon's passage. Madam Speaker, I don't know, I think he's now partyless and homeless and moving around the place at different venues, Madam Speaker. He raised issues dealing with allegations of corruption. So, Madam Speaker, is this whistleblowing protection unit here? Is this for Harry Raghunandan, Leon Grant, Ronald Ford, Charmaine Lewis, Karianne Morey, and others? Is this for that? Madam Speaker, where the employer, now in every ministry, as I understand it, correct me, every ministry and department need to have a whistleblowing officer because they're in the public service. And you don't say how they're appointed, who hired them, who are approving their terms of conditions. Madam Speaker, in ministries, it is the minister, unless it change, that these files come to approve terms and conditions of work of officers. Now, it is, for many of us, it was a routine matter because they have all the process, they follow, PS recommend, and so on. But Madam Speaker, there are evidence in this country where that was not a routine matter. So a minister of government has to sign off on the appointment of a whistleblowing officer in his ministry, department, etc., etc. That is a dangerous thing to do. This is why you have to put more thought, and Mr. Attorney General, you ought not to have run away from a joint select committee. You ought not to have run away, and we can help the opposition, as we did with all the other bills, can help you, because the objective is not a bad objective. We can help you, but you cannot run away from a JSC. You cannot set up some type of amorphous structure where we don't know how and in the world this thing will be operationalized because you want to deal with something immediately. We all want to deal with something immediately, Madam Speaker. We all want to deal with that. But we must protect citizens' rights. And I think that the Attorney General, he sounds convinced. I think he sounds convinced. He's clear as to his objective and so on. And as he speaks, I'm going to say the last government, Madam Speaker, the outgoing government will be subject to this legislation. And therefore, it must be good legislation if I or anyone on this side would have the displeasure of subjecting any one of you to this legislation. Madam Speaker, it should be good legislation. I thank you.
Prime Minister.
Madam Speaker, I joined this debate just at the time when I thought it was being given serious treatment in this Honorable House. It deteriorated to a bit of jocularity. But having said that, Madam Speaker, I simply want to go on record saying that this piece of legislation arriving here today is not out of any act of urgency to deal with any specific situation, as implied by my colleague from Oropouche East. Because these are the kinds of comments that lead the population to believe that we're never serious and that the House engages in matters against their interests. I recall, Madam Speaker, as leader of the opposition in an election campaign in 2015, raising with the population the all-pervasive nature of corrupt practice in Trinidad and Tobago and the effects, the deleterious effects that it was having on the society in our development and growth as a nation, in our use of resources, in the development of our human capital, in the restraint of the population's ambitions to be realized, and so on. And as part of the election campaign, people talk about promises made in election campaigns. I prefer to talk about commitments. A commitment was given that if this government, if this party was elected to office, we would put the structures in place to attempt to restrain the runaway growth of corrupt practice in Trinidad and Tobago. And we did that on the grounds that a lot of what was happening that was so detrimental to the public well-being was not being done either in secret or without the knowledge of anyone. Much of what was happening was known to some people or somebody, and therefore, if that is known to law enforcement, then the population would stand some chance of treating with the scourge, and we'd be able to turn around this juggernaut. And that is why in that election campaign we committed to take steps to bring to the Parliament whistleblower legislation. Meaning, not that we are creating any wheel, inventing any spaceship to go to Mars, but putting in the legal structure, in the jurisprudence, in the toolkit of law enforcement, another item which will assist us in treating with wrongdoing wherever it might occur. And that's why the Attorney General was able to say that this is not only about wrongdoing in the public sector, but in the private sector as well. And let me make a point on that, Madam Speaker. A few years ago, which is before I became Prime Minister, or it was just as I had become Prime Minister, I had the opportunity to be addressing the Chamber of Commerce at West Moorings at their headquarters down there. And somewhere in the proceedings, when I was taking questions from the gathering, it was said to, someone at the back of the room made this very big point asking me, what is the new government going to do about corruption in the public sector? And I said to him, we aim to do a lot. But may I remind you that 95% of the corruption that occurs in the public sector has some connection, usually, with the private sector. Correct. And the audience cheered, and that was the end of that conversation. So that's why the AG today is saying that this legislation is not about only public sector corruption, because public sector corruption hardly ever is confined to issues and personalities within the public sector. In fact, a lot of the inducement and enticement and the acceptance of it is in the public sector, in the private sector, in the public sector, in the private sector, sorry. So let's not put any barrier between them. It is the citizenry, wherever they're located, that are harmed by this, and its growth and fertilization is among the citizenry. So let us not take it personal. Let us not seek to pigeonhole it. I heard my colleague from Orapush, he said that it needs to be narrowed to be specific. You don't know who is going to be the whistleblower. You don't know what they're going to say until they come forward and say, I know something about something. It's no place, no name, no time. It is only when the whistleblower comes forward and tells you something of interest that you know that this is whistleblowing. So how could you want to pigeonhole it? It ought to be left wide open, wherever it is. URP, local government, central government, business sector. That's what you need, wherever it is, because we are damaged across the board. I'm sure everybody in this room, all my colleagues here, know stories that they've heard, and they're always stories about something that happened in URP, in CPEP, in the ministry. I mean, Madam Speaker, we get some reports here from local government sometimes 10 years late, and you look at them, and frankly, I just throw them aside, you know, because what can you do then? 10 years later, first it comes late. Secondly, you could see that something is not right here, but how do you deal with it? And somebody knows what went on there. But you have to just swallow it and say, this is Trinidad and Tobago, that's how it is. What this legislation is meant to do is to encourage and protect people who are volunteering to tell you what they know that may be of use in treating with this problem. Because at the end of the day, Notwithstanding the fulminations of my friend from our Approach East, nobody is forcing or creating any whistleblower. All that is just old talk. A whistleblower is going to be a citizen who takes it upon him or herself to volunteer information, which they believe is for the public good. That is the only whistleblower that this legislation acknowledges and expects to come forward. And if they come forward, Madam Speaker, I heard a very strange comment from my colleague from our Approach East today, talking about giving people enticement and inducement to be a whistleblower and so on and so on. All I will say to him, that is a poor defense for today's headline. Very poor. And if I were you, I wouldn't demean the House by raising that here and trivializing a serious debate. Madam Speaker, my colleague from our Approach East spoke about a minority report should have been allowed to be made and so on and so on. Madam Speaker, they talk about us hurrying here with this. We did not. As per the commitment we made in the election campaign in 2015, it is now 2019, early in 2016, in fact, I am now reminded, it was November 2015, we came in on September 9, 2015. Let me repeat that. For those who heard about rushing and hurrying, we took over the government of this country on September 9, 2015. October, November. 2 months later, we laid in this parliament our first attempt at the bill for whistleblowing legislation to be brought into law. My colleagues on the other side requested, and I dare say demanded, that it be sent to committee, as they've done with virtually every piece of legislation that we brought here. They were in government for 5 years. The issue was there. They never touched it. We committed to dealing with it as an election campaign promise, commitment. We brought it here inside of a month. And when it got here, my colleagues wanted it in committee. It went to committee like many other things. And after going to committee then, it is today almost 4 years later, we are treating with it on the parliament floor, and I'm hearing about us rushing it. It was their intention, Madam Speaker, if I'm to interpret it, that the 5 years would have passed. And even though we would have brought it here with such alacrity in 2015, that it wouldn't have seen the light of day. Today, the matter is before the parliament. And what can I say, Madam Speaker, about a minority report? I have had the experience in this House to see my colleagues on the other side beat matters to death in the committee stage and put in a minority report. And when the matter came before the House to be dealt with, they disowned the minority report and continue to be obstructionists on the matter. So to come and say today that you had no opportunity to do a minority report on this matter is such a big point. It's a non-point. What it does say, Madam Speaker, is whether in fact we agree that this problem exists in this country, and I'll come back to that. My colleague on the other side talked about being a whistleblower himself. And had this law been in place, he'd have been protected. He invites me to respond to that, because we're getting personal now. He's a whistleblower for coming to the parliament and reading documents about bank accounts and calling my name and getting his end sued and not saying that the law, if the law was there, wasn't going to protect him. He would have had to answer for serious misconduct, because that is the malice that the law is saying must not happen, because the law protects people from that kind of behavior. Let us disregard that from the debate. He makes a big point about a whistleblowing officer and who is going to appoint him and who's going to create this job. And Madam Speaker, when our people who are busy out there working on the buses, working in taxis, the hotels, here in the parliamentarians saying that en passant, they believe that some serious point is being made in the Parliament and something, Madam Speaker, this is not a real point. We have just, we spent a long time dealing with trying to bring to a head this whole question of the procurement legislation. Correct. And in that legislation, it talks about a procurement officer in every department. Madam Speaker, what we discovered is that some people interpret that to mean that you go out and hire a whole cadre of public servants who will be procurement officers. A department that is only dealing with $1 million in procurement might have an establishment, according to them, of a $10 million department of procurement. We said no. What the law is saying is that you designate some officer as that, as part of their duty. And it's only if you don't have such a person who you can pass that responsibility on to, then you will have to hire somebody to do it. But we are saying that in the public service, we're showing all the ministries. We had what you call it, they brought the PSs and deputy PSs and explained to them that the procurement officers are not that you go out and hire other people. Find somebody within your department who will be designated and identified to do that when it has to be done once in a while in your department. Would you believe, Madam Speaker, that even after all that, right down to the end, we're still getting cabinet notes. Permanent Secretary is still sending us the big long establishment to hire procurement officer department. And says, no, it's not that. And look at what happened to you. Same thing. We are saying here that you identify someone within your organization whose job is simply to receive the information. And it's being done already, even before the law in Angostura. Those of you who follow the Angostura issue, in Wassa it is happening. So it's happening already. And always saying that a person will be designated, and that person, he or she, or even more than one person, will receive, if a person wants to talk to you about something interesting like this, they know who to go to and where to go. But you come here and making a point about it, about the law is defective because it calls for this and operationalization. Madam Speaker, that kind of argument could be made, or could have been made when the police service was going to be formed. When Vincent Peel was going to form the police service. Because you could have said, you go and give policeman uniform and give him baton and give him power to arrest people. What all kind of thing could happen? They could arrest people on false information. They could beat people out of malice. All of those things could be said about the police. But we had to have a police service. And these could happen things, could always happen. It reminds me of a cousin of mine who refused to get married. Because he's afraid he won't get home. And was told by my other cousin that my grandfather lived with it here, my father lived with it, and you will have to leave it here, but marriage is a noble institution. So when that kind of objection is being made to legislation, it's not serious. It's not a serious point. And we, Madam Speaker, what we need to do, what was even more, as my colleague from Orapuchis got very personal on the matter, in talking about who was whistleblower and who wasn't whistleblower, and who will designate this whistleblower. Well, the angel Gabriel is not available for that purpose. There are positions that have to be appointed by persons in authority to appoint them. Whatever the shortcomings are, appointments have to be made by human beings in this country. He talks about whistleblowing and the shortcomings of the appointment. I want to remind my colleague from Orapuch East on this question of appointment of whistleblower. There was a Solicitor General called Honeywell Donaldson, who wrote complaints to our Prime Minister. Serious complaints about misconduct in a serious government department, criminal conduct. And the Prime Minister sent it to the Attorney General to deal with it. That was a whistleblower, and the Attorney General was the subject of the complaint, and that was how it was dealt with. And not once, Madam Speaker. Twice. And now he's coming here to talk about How are you going to appoint the whistleblower? The Attorney General was appointed whistleblower in the AG office, and that was how it was dealt with. So there's no foolproof protection of how it will be dealt with. All we are saying, create the law and let the volunteers who will so do it be given the opportunity, and this is just another tool that can be used in some circumstances. That's what we're saying. And to add insult to injury, he goes on to name a number of people who were the subject of mistreatment by this government. Madam Speaker, I can't let the record go unchallenged. He having named them. Charmaine Lewis, who was the acting general manager of the port, was removed from her job, not because of any appearance in front of any parliamentary committee, but for the findings in a forensic investigation at the port. He had the gall, Madam Speaker, to mention Leon Grant's name. Madam Speaker, Leon Grant was removed from the port after the Prime Minister of Trinidad and Tobago, your humble servant, came before a committee of this parliament, showed them documentation where Leon Grant hid pertinent information from the port, allowing that Cabo Star to be bought and brought here at thousands of US dollars per day more than the owner wanted to do it for. And it was only when the whistleblower, the previous owner, communicated with me, telling me that they offered the boat while they were the owner, and that was hidden from the port board, that I came to the parliament here and showed, and that's on the parliamentary record because I put the emails from the previous owner on the parliamentary record. And today he has the gall to come here and talk about Leon Grant being moved out of state. Yeah? That is what they get up to, you know, Madam Speaker. The complete opposite, as though Leon Grant was wronged. Leon Grant was a public officer whose conduct came to us in that way, by whistleblowing from a foreign whistleblower. And you come here today to point finger at this government in defense of Leon Grant. You and Leon Grant have a lot in common, and we are not going to take it up from you. He talks about Ford. Talks about Ford at the PTSC. Ronald Ford at the PTSC. Madam Speaker, at our party headquarters, we have removed people on frequent occasions whenever it occurs that they are unsuitable for membership in our organization, and we need no assistance from Orapuch East. And since he wants to talk about Harry Ragunanan removed from Balize House, when we move him out, you bring him back in. Madam Speaker, he was moved for good cause. And I draw your attention. There was cogent information available to our party that the conduct, especially, and in fact, that conduct had influenced Mr. Grant was out of his job for a few days, wasn't it? Yes. We woke up one morning and discovered that Mr. Grant was put out of his job. It had nothing to do with his appearance before the Parliament, Madam Speaker. Nothing. It had to do with improper conduct at the PTSC on the part of persons who have been dealt with appropriately, including removal from the People's National Movement. Madam Speaker, I simply want to spend the few minutes that I have left. How much minutes I have left? Pointing out to this country.
15 minutes, 37 minutes.
Pointing out to this country that there are reasons for us wanting information from whistleblowers. Because we know that there's a lot of wrongdoing taking place in our society at various levels. We know that people know what's going on. Somebody knows, and the information that some people have would be useful in helping us to eradicate that problem. I take you to 25. I take you, Madam Speaker, just for illustration, not to debate the report, but I take you to the report of the Financial Intelligence Unit of Trinidad and Tobago, 2018 annual report. This is the most recent report laid in this Parliament by the Financial Intelligence Unit, a body that this Parliament created for the purpose of treating with wrongdoing and criminal conduct where information of wrongdoing is the raison d'etre of this organization coming into being. Parliament created it. We didn't always have it. We created the Financial Intelligence Unit to deal with financial wrongdoing in this country. Let me tell you what this report in this Parliament, sitting here in attendance. I take you to page 21, Madam Speaker. Suspicious activities disclosures. And again, remember, it's financial. This deals with financial matters. Money, meaning that wrongdoing where money is either obtained, beneficiaries are breaking the law or something like that. And we created the conditions for suspicious activities to be reported and collated and expected to be pursued and prosecuted. That's what we expect. But of course, the report comes to the Parliament, the country might hear about it or not hear about it, goes on a shelf, and it continues. Comparisons between 2016 and 2018. Suspicious disclosures for that period. Banking, 2016, 284 of them. 2018, 463. Insurance companies, 2016, 31. 2018, 70. Investment companies, 2016, 15. 2018, 25. Non-regulated financial institutions, even small people's money, cooperative societies, 86 in 2016, 42 in 2017, 51 in 2018. Money transfers and wire transfers, 2016, 217, 2017, 325, 2018, 444. In total, of all the other, when you had all the categories, including lawyers, jewelers, motor vehicle sales, real estate, gaming house, total, 2016, 739 reports. 2017, 877. 2018, 1,100. So in other words, it is there alive and well and apparently getting worse. More reports, and we are assuming that more reports are an indication of an increased activity where these illicit transactions are taking place. But interestingly enough, Madam Speaker, of all the headings we have here, the one that caught my attention the most was private, was gaming house, meaning gambling arrangements, which in this country where we turn our face away from the sun, hoping that people will say it's the moon, we have no proper legislation in this country acknowledging the presence and operation of casinos, but the whole country is awash with casinos, handling millions of dollars, probably billions of dollars, serious criminal conduct associated with them to the extent where the banking community had to withdraw their service from them. Correct. And the only prosecution against that group of economic activity has been done by a foreign country about activity in Trinidad and Tobago. But in our parliamentary document where we talk about our conduct as a people, 2016, gaming house reports of transactions that are of concern to us, 0. 2017, 0. 2018, 0. Madam Speaker, how could we as a people be satisfied with a report like that, where every school child knows, every businessman knows that money laundering threatens his business, and one of the perfect places to launder money is like casino construction, casino operation, but the Parliament accepts a report that says 0, 0, 0. And I say, and we say, the Attorney General says, and this law says, somebody knows, and we want those people to talk.
We protect them.
And we say that as they speak about what they know, they should be protected. And as my colleague from Orapuch East understands as well, that if they use the legislation to be malicious or to try to damage people through misinformation, the law says that you can be prosecuted. Nothing new. The same condition exists in the Integrity Commission Act, where if you know something or if something is wrong,
correct,
you can complain. But if your complaint is deemed to be for malicious purposes, there are penalties that can be attached to you. We know that. So this is not new. We're simply saying that the same condition will apply here. If you think you're going to be a whistleblower for the purpose of being malicious and hurtful, then you are exposing yourself to damage.
It's in the public procurement.
But it's in other legislation. So why come here today and say that this is something that's going to be so hurtful and it is not acceptable? My friend went as far as to quote the public officer who talked about how the court might rule, referring to legislation which is not before us today. That comment was not about this bill. It was about a different draft.
Correct.
And to the extent that we've taken the draft from where it was and brought it here in this form, we have taken that on board. And of course, there's a lot of our daily existence that the court can rule against. But when we go before the court and tell the court what we're dealing with, and we have to assume that those who sit on the bench in the court in this country live in this country, and they too see this report, and they too read this report, they will then have to determine if they will protect us by deeming that this is not something to spite anybody, but something that this society needs if we are to improve from where we are to where we want to go. So to come and say that somebody say that the court might rule against it, that is always the prerogative of the court. What we have to do here is to put our heads together and make the best piece of legislation available. We all represent a portion of this country's population, and everywhere in this country, every citizen is exposed to what I'm saying here. Everywhere. None of us here has a population in our constituency that is immune from the deleterious actions of the wrongdoing that this bill is seeking to deal with. None. So we will do the best that we can. And no legislation is perfect in its drafting or in its promulgation. You can always, and sometimes by experience, you come back and amend it later on if you have to. That's why the Parliament deals with so many amendments to old laws, even new laws you have to amend. So don't come and tell me we can't enact it into law because you could point to some little shave, some little thing that could cause it not to be operational. We have worked on this legislation for 2.5 years. And we are now in a position to say to this Parliament and to our colleagues on the other side, let us enact it into law. Correct. It will always remain a voluntary action of persons in their place of work or their place of worship, I dare say. Because even the places of worship are not immune to the wrongdoing that is so pervasive in Trinidad and Tobago. And when it is there, all it will do is to give, firstly, an encouragement to those who know and will want to talk.
Your original time is now spent. You're entitled to 15 more minutes to complete your contribution if you wish. You may proceed.
It will give that encouragement to persons, and especially those persons in the public sector. And I tell you why the public sector. Because the vast majority of the criminal conduct that this legislation would probably identify have something to do with public money. Because the grease that turns the wrongdoing in Trinidad and Tobago is public money, invariably. Because the way the country is run by a national budget funded by the state, and the amount of service that the state provides to the population funded from the exchequer, creates huge opportunities for persons to interface with public assets and public monies. And it is there that the wrongdoing is taking place. And those persons are organized in ministries or in local government bodies or in private, state enterprise sector bodies and so on. And therefore, persons who are either employed there or who do business with them or who are observant of what is going on, those persons in protection of their own interests would want to say what they see that is going wrong and would want things to go right. Correct. And they would want to talk to somebody. Madam Speaker, a simple thing like the use of public vehicles for private purpose. You would not believe how much abuse takes place. I mean, this is not to trivialize the situation, but you would not believe how much abuse takes place by persons using public vehicles for private purpose. And you would also not believe how much resistance there is to the government to have departments mark their vehicles with government mark, because the users want to make sure that the vehicles are not identified when they are being abused. One of the instructions that this cabinet gave across the board in the public service is that except for security vehicles and few other exemptions, all public vehicles ought to be marked as such. And the reason for that was to prevent them from being abused, millions of dollars of abuse. Madam Speaker, you would not believe how much resistance we have been getting from the public sector to prevent that from happening. Because once you see a vehicle with a government logo on the door on Maracas Beach on Sunday morning, you know it shouldn't be there. And they have been resisting no end. And you might even ask, how could they resist the government? And I say, easy. Just don't do it. And give you reasons why it shouldn't be done. Or postpone it. Or just pretend not to hear. I would say, even though there was a cabinet instruction that those vehicles should be marked, very few departments have carried out the instructions. And you inquire as to why it's not being done, and they pretend not to hear you, and they'll wait you out until after the election, hoping for the next government. That's how it goes. And I'm saying you would not believe how much millions of dollars we will save in gas and tire and vehicle if public vehicles are used for the purpose for which they are bought. So you will see all kind of vehicle on the road. Nice model, nice hairstyle, nice driver on a government vehicle, government gas, government tire, government maintenance. You taxpayer paying for that. But of course, if the vehicle was marked, you could then complain very simply by taking the number and calling the department and hope that somebody in authority will take that. Madam Speaker, that's just a small end of it, right? You heard today about $100 million reference to something wrong. I will tell you, Madam Speaker, I am going to ask this House, as I've asked the Attorney General a few months ago, to make sure that this bill comes to the House and it's going to go to the floor. If my colleagues don't vote for it, it won't be passed into law. But I can tell you, Madam Speaker, every member on this side will vote to put this into law. And the least that we could have done, as a party coming into government with the approval of the electorate to put this into law, was to have ensured that the Attorney General's office, and I want to congratulate the Attorney General and his staff for the speed at which they brought this matter to the Parliament. They did the research. We are not going to be the only country in the world to have this. We were able to look at a number of other countries that had the same problem. These problems are not peculiar to Trinidad and Tobago. In the Commonwealth, there are a number of other countries that before us had seen it fit to enact this legislation. Correct. Coming after them, we have been able to look and see what they have done. Their courts have not struck down their legislation as being unconstitutional or inappropriate in a society like ours in the Commonwealth. We have been able to look at them and then say, this is the form that we will pattern, we will learn from it, we will build on it, and in fact, ours being newer would be better than some of the old ones that are on the books of other Commonwealth countries. Because we've looked at what they have done, we've spoken to them, we've got their experience. Some of them have offered us their staff to help us in the drafting. So what is this story about? We can't enact this because something bad about it. If you don't want to support it, say you're not supporting it. It's as simple as that. But it cannot be on the grounds that is unsupportable, and that the courthouse will be a place where to be struck down as not being reasonable law in a society with proper respect for our rights and so on and so on and so on. That is just an excuse. It is here today calling on the parliamentarians to put it into law so that those who are required to enforce the law will be able to use it in appropriate circumstances. Madam Speaker, these kinds of comments in the House, as though those of us who have the responsibility to bring the legislation, to prepare it and to bring it, that we have some personal agenda against a personal individual situation. We have to remember, from the time we pass it into law, those of us in this group have absolutely no say whatsoever in dealing with it. Because it is only the police in this country, only the police in this country has the authority to arrest anyone. And even that, there's a security there. If the police, as is in, Madam Speaker, could you ask Naprima?
Prime Minister.
Madam Speaker, even where it can be said that the police may abuse their authority or be guided by a political directorate to go after XYZ, they could say that if they wish. Section 90 of the Constitution put an additional protection there. The office of the DPP, beholding to no one, no person, no agency, has the power to intervene and stop prosecution or to initiate it if it's so serious. So we have the DPP's office. And the reason for that is that if there's capricious action on the part of the Commissioner of Police and his men and women, the DPP can step in and put an end. So, Madam Speaker, what is this fair? And what is this thing about trying to personalize legislation? There's no such thing in this country as PNM law or UNC law. It is the law of Trinidad and Tobago applicable to everybody in this country. Much of the laws that we wake up to and are governed by, we have no idea who enacted them. In the Parliament at the Red House, where we hope to go very soon back to the Parliament building, there were some busts and pictures in there of people who were from the Legco days, even before independence, who were the ones who passed laws in the last century. Those are the laws we live by. I don't hear anybody getting up and say, Devatai passed this and this one do that. No. The laws are for governing our society. And from time to time, as we evolve in one direction or the other, we amend the laws or replace the laws or we add new laws. Why are we afraid to do our duty? Today, Trinidad and Tobago expects every parliamentarian to do his or her duty today. If that is too much for us in our time to do, then the failing will be on our part, and our period of service would be one that we ought not to be proud of. Madam Speaker, I ask my colleagues on both sides of this House to accept this legislation in the spirit in which it was committed, in the spirit in which it was prepared, in the spirit in which it has been brought here, and in protection of the people of Trinidad and Tobago, where many people know a lot. Everybody knows what ought to be done. A few people know what is going wrong, and we can then use their information to treat with a chronic problem in Trinidad and Tobago, and that problem is the all-pervasive corrupt practice that seems to be getting worse in Trinidad and Tobago. Madam Speaker, I ask my colleagues to support this bill and enact it into law. Thank you, Madam Speaker.
Well done. Member for St. Augustine. Member for St. Augustine.
Madam Speaker, it is truly an honor to speak after the learned and most honorable Prime Minister. Let me just indicate up front that as I speak out of love of country. I have no cocoa in the sun, nor do I have fear for any man. Indeed, as I stand here, I can tell you with all honesty, I really do not know if I even have a future in the electoral politics of this nation. And I say that to put in context in response to what I consider a very aspirational statement from the Prime Minister. But we live in a real world. Prime Minister, please do not take this as any personal attack. But at the end of the day, and in the beginning of an era, the question must remain, is it not that all of the laws that we pass, many of our colleagues may become subject to them, at the end of the day and the beginning of an era, it is to the courts that we look. How is it reasonable in a modern democracy, Prime Minister, that Section 137 has not been triggered? And I ask the Honorable Prime Minister,
Member, I remind you of Standing Order 48.1, relevance. I'm going to give you a very short, but I don't see the relevance of this.
Yeah, I'm most grateful, because I shall make it most relevant. If it is that out of these whistleblowing legislative efforts, if it should become law, and persons become subject to this law, it is to the courts, as the member for Oropuch has indicated, as to whether this law is applicable in the society, and the learned Prime Minister did in fact reference that. And it is to the court that will determine whether those or this legislation and others will stay on our books and become applicable to any citizen. And that when I reference, and I know the learned Prime Minister may not have fully appreciated the circumstances, and it is my duty as a member of the Parliament, a colleague of his, of course, to indicate that the perception where you have been called upon to do a duty that only you could perform, you have made no decision one way or the other, whether you're going to appoint, my lady, with all due respect, this is, I'm about to close.
St. Augustine, I know sometimes when we're in full flight, it's difficult to contain ourselves. But I rise again on relevance, and I would ask you to move on to another point, please.
You see, it cannot be where judiciary that will apply the laws on our citizens can be held under the sword of Damocles, one way or the other. And when there is issue as to who is afraid of the application of law, let me tell you why. For the longest while in this Parliament, whenever legislation is brought, whether it is that issue of explain your wealth, or the SSA, or other legislative efforts that came as simple majority matters, many of my colleagues and the wider population said, but this can't be. If we are dealing with this issue here of whistleblower legislation, you said that because it is required as a constitutional majority, you ask all of your colleagues to support it. Then where is the argument? Where is the consistency when other legislation that indeed impacts upon one's privacy and on property rights, you bring it as a simple majority? And when there is a condemnation of that effort, all you have things to hide. You have cocoa in the sun. You're afraid it. Unpatriotic. Almost treasonous, my dear friend from Laventille West. And that is why there is a discomfort and an unease in the politics that a lot of the legislation is part of theater. Part of theater, where the opposition now has been painted as totally corrupt. The population has been groomed to expect anything and everything, so that when colleagues may be arrested and or prosecuted, they say, you see, we always knew. And thank God for the PNM, great is the PNM, they are holding the law.
Order. Member for St. Augustine, continue.
Tables. But the great charade is that legislation that has slipped through this House with the best of intentions by some, I imagine, for instance, this issue of explain your wealth, will fade into disgrace the moment it is tested before the courts.
So, member, I believe what we're dealing with today is whistleblower protection. So I'd ask you to come back to that, please.
I have not left at all, because it is upon that foundation other legislation will be placed to suggest that it is a portrait, a picture that is painted of the crime-fighting and corruption-busting efforts of the government, which I congratulate. If there is a genuine effort to deal with corruption, nobody will herald that and be more grateful for it than I, and I'm sure many of my colleagues. Yeah. But the most important legislative effort of this Parliament, or the Parliament of Trinidad and Tobago, has been procurement legislation. And 4 years into the term, we have not seen a single effort, I shouldn't say a single effort, we have not seen the light of day for the enforcement of procurement. And the Prime Minister was so 100% right on it, that corruption really involves government and people's tax-paying dollars being spent and private enterprise. And that is where we need, and if you're really serious about busting corruption, let us implement procurement now. 4 years. 4 years. 4 years. On the books, but not developed. In fact, it is no secret, I have a meeting with the procurement board this week. They've asked for any assistance I could give. I do not know if I could, but I will do anything I can to further that effort. I was so lifted, Prime Minister, when you invited many in our country to visit with you for the introduction, or at least the beginning of the effort, for campaign and party finance reform. If I recall, that would have been in January 2016. Promise after promise that would come. I'm hearing, Prime Minister, that it's coming very shortly. Sorry? I look forward to it. But when will it be implemented? For this local government election coming? For the next general election? And the reason I say these things is because we are dealing at the foundation here of corruption. It is, as the Americans say, our political system is now baked in to it. Party and campaign finance. Because whoever pays is to be repaid. And unless we deal with that also, which was an effort started under the last administration to balance off this thing, then we are really just taking little chinks when you have a sledgehammer to deal with the major problem. So, Madam Speaker, nobody disputes the value of whistleblowing. In fact, in the United States, many may not recall that there was a leak from the presidency of the Nixon administration. And one recalls now, too, that the whole Watergate scandal came about from an illegal breaking into the offices of the Democrats, or the other way around. But there was a person whose name or nickname had been given as Deep Throat, who was able to give information, and out of that, the media got involved, and the media was able to expose so many things, at the end of which the presidency of the United States, the presidency of Richard Nixon, fell. And there are many examples, some quoted by my friend from Oropuch, some quoted by the Honorable Prime Minister. So there's no denying that it is important. But what do we have in this legislation? And let us not understand the severity of what this is all about. Where a person who has information comes forward under sometimes the veil of being anonymous, but we are encouraging those persons, and I'm attracted to the suggestion from Oropuch East, that it should not be left for internal reporting structure. Because the moment a person in an organization says to a person who is selected by the boss man, if I may use that this person talking about some corruption, there's no guarantee You could put law. But if that officer should whisper into the ear of the boss man, look, Mr. X, Rudy from Couva South, talking about corruption, you now imperil the life of that person. Mm-hmm. And that is the hard truth in Trinidad and Tobago. I wonder what was the cause of the death of that family just south of C3. I wonder what was the cause, what was the motive behind that? And forgive me if I get a little passionate. I know that woman, I knew her 2 little children. Every time they see me, they hug me. One is now dead, the mother is dead. And we don't know. Executions take place in this country without response. Mm-hmm. And I congratulate the efforts of the police who have lifted in some way the confidence in our people. And I shall come now, in a short while actually, to the issue of the police being able to arrest and to charge. But we cannot move away from the reality of this country. Madam Speaker, I do not know if you recall, but years ago, a senior manager of TN Tech was murdered outside of his home. In a shorter time frame, some manager or managers at WASA have been executed. Word on the ground is that these were men who saw the corruption and they were willing to take some step to deal with it. They're now dead. So we cannot be speaking about whistleblowing legislation unless you fix witness protection. Attorney General, I know your passion. Minister of National Security, I know your ambitions. But that is a first and foremost requirement if we are to make any of this thing real. I know persons today whose homes, as a member for Laventille West, I'm grateful that you brought the legislation for trespass into homes and so. But they are afraid to make reports on it because they know if they do so, they're dead. I know persons whose commercial or rental properties, persons have overstayed and not paid rent, and now they're afraid to take legal proceedings against them because a hit is just that. Understand? Remember for Chaguanas, that is up to $500 a human life is valued in this country. So let's understand why there's anxiety in dealing with putting structures that now expose persons to believe a false sense of hope, a false sense of promise, that they are to be protected. To say that there's a fine, that if you disclose who this whistleblower is, that you could be fined and put into prison. How are you going to prove? That I tell Rudy, listen, I have no corruption in that place. And Rudy tells his wife, say, you know, as an example, that something is wrong and somehow, you know, try that. Little talk goes out and we know who that problem person is. And they remove physically from our life. So this is not something that we should just consider with glibly. Let me put it like that. I suggest, just like Oropuch East has suggested, remove the requirement for internal reports. This is not America where we saw the value of whistleblowers in the tobacco industry. Remember for Barataria, where internal memos had shown that cigarettes caused cancer and death. This is not America where there are thousands of persons working at the Ford Motor Company, as an example, who showed that who disclosed that there were defects in machinery and vehicles that caused death. Where what benefit and protection you say you're going to get, you can't fire them, you can't change their conditions, you can't demote them. That is a different culture. Which industry in this country has the hundreds of thousands that we could say that will protect, that you will continue to work in an organization that you have made a complaint against that could cause that organization some harm? Which? And the way it is drafted, with all due respect to the very able and patriotic members at the CPC's department, how could you draft here that you are required, because that is what the effect of this is, every employer, where they have one employee or 1,000, are you required to have a whistleblowing officer? Prime Minister, you're right. It's not that you go out and hire, but you take somebody who's already there. And you designate who? Who are you going to designate, boss man? Your most trustworthy.
Yeah.
Your most trustworthy person who will come and tell you, hey, listen, we have a problem with that fella. So let's avoid that and go directly now to the institutions, the 20 that are there already. And if you want, create one big institution that will collate everything and then send it to the different institutions as you deem fit, so that the average citizen wouldn't be confused whether he should go to Integrity Commission, whether he should go to the police, whether he should go to the EMA, whomever. Let's create a whistleblowing organization, quite similar maybe even to, what's the name of the Crime Stoppers, as an example, where anonymous information is given and you filter it through, you do some investigation, you go up the road. You do not expose people to potential death. Prime Minister, you were right and you were wrong when you suggested that in the government that you didn't have to hire a whole set of people. Of course, because we already have a structure of paid public servants. But to put that burden on small business, medium business, or whatever other business, parlor, shop, or whatever, really is onerous. And the law does not give you any structure that how you are auto-populated. And as a member for Oropuch, I don't want to over-accept all he has said, which I think his submissions were very, very valuable. And notwithstanding his style of bringing a level of levity and a very important graciousness sometimes to the floor on very important issues, but it's not to be denigrated and to be thrown in the corner that whatever he says is of no value. No, because as he's indicated, he has been inundated in rumors. I do not know where they came from, but we do know these rumors. And therefore, persons like that, or any one of us, could be relegated to insignificance because they just offload it on them. Anything they say, they are cocoa in the sun. They are afraid, they are afraid, they are afraid. And that's why I open by saying I have no fear. I really have no fear of any of this, but I must do my duty to the government and to the people of Trinidad and Tobago, and certainly to the opposition and the opposition leader, who has for a long time been the subject of a lot of rumor mongering, for a sole purpose, I imagine, to undermine the democracy of this country. Because when we do this, that every bit of legislation, whether it's FATCA or whatever, that the opposition is opposing for opposition's sake, that we don't want it because they have things to hide, what are you telling the population? The legitimate opposition is not worthy of office, and only you are worthy of office?
They are most unworthy.
I am not to point fingers, but the country knows what is going on. And Attorney General, there was a very good point, very brilliant submission, that you too will be subject, because it is your 40 and you have your history being in government from September 2015 and therefore subject to it. Let me ask one question. Who in this country, or how few are they who are brave enough to make a complaint against a sitting government? How easy it is when the country has been groomed that a former government is not to see office in the future, so therefore you can go after them. And this is an attack on the democracy, because if you destroy credibility of all those who oppose you, all you're left with is what? What are you left with if you have no opposition? And that is what the structure, the environment that has been created is all about. So, Prime Minister, Honorable Prime Minister, you have in fact in the past made statements that I agree with, that the professionals in this country have failed the people of Trinidad and Tobago. As a friend of mine, a colleague lawyer said, we have a road mafia in the country, a highway mafia. We don't mean that people who hold you up on the road, but hold up the people when they fix road. The reason I'm saying this country spends billions and billions of dollars, whoever in government, year after year. Member for Aruka, you know this. Where the quality of the road, and I just give you an example of why whistleblowing could be important and useful. 1 month after they finish pave a road, it mash up. Who is it that certified that work as being good and appropriate and passable? Who? It's somebody lower down. But you know who is getting blamed for it? Minister of Works. Everything in the country, figure at the head of it is bubble, corruption. And therefore, there is a responsibility, and that is why explaining your wealth could be quite useful if you go after the right people and not be selective in who you go after. And that is where the problem is. The selectivity of who becomes the subject of law, who becomes the subject of investigation and therefore prosecution is what the real issue is at the end of the day. My dear friend Gary Griffith, and I say that because I think that he has tremendous value in what he is doing. He has lifted the confidence of the population and certainly to members of the police service. But when a government distorts the process by which a commissioner is chosen, you ask yourself why.
Member for St. Augustine, I want to say that you're offending the standing order and that you're imputing improper motives. Okay? I want to say that you're imputing improper motives. I ask you to withdraw that. Again, I remind you, even though to some extent I understand the broad issues, I remind you that what we're dealing with is whistleblower legislation, and I'll ask you to come back to that. So please withdraw the statement as it offends the standing order with respect to improper motives.
I withdraw it unreservedly. Unreservedly, I withdraw it, but we do know that the process that was used...
Unreservedly cannot have but. Unreservedly cannot be followed with but. It can only be followed with a full stop and a new thought.
New thought is this, that the process used was different from what we had grown to expect under the law. I make no aspersions on the good commissioner. Go on with your work. But we have a history in the country that I cannot avoid. And the history is you look at and to see who has become, repeatedly, we have to reference our history, but we have to learn from it. Who is it? Who have they been? Those persons who have become subject of these kinds of laws, integrity legislation and so on.
TPS rule.
Please, again, I am cautioning you, let's deal with whistleblower. I'm going to give you a little opportunity to link that last statement with what we're doing. If not, move on to your next point, please.
One of the scheduled listings is for the Integrity Commission. As a designated reporting authority. And therefore, the Prime Minister, you see, when the Prime Minister spoke, he spoke about the environment of the past and the present and the future that he wishes to see. And all I am doing is going in the same road on that road. So I don't have to remind you that only Pandey get prosecuted, only Fingar get prosecuted.
Tim Gopi.
Tim Gopi Singh.
Madam Speaker.
I don't have to remind you
Madam
that.
Speaker, the member continues to impute improper motives. I'd like a ruling, please.
Having regard to the context, I don't see it as imputing. Please continue.
Thank you so much. But forgive me if I troubled you. Forgive me if I troubled you, Madam Aruka. I know you've been in the PNM for long. I don't know if it's guiding minds. So forgive me, I did not intend that, but I'm just looking at our history to see who have been prosecuted, and then in the environment that has been created, where there's a threat all along, we will see. We'll see.
WPC.
Now,
Warrant officer.
So, Madam Speaker, I do not intend to be much longer because I think that I have dealt with most of what the Honourable Prime Minister had spoken to. However, we cannot likely ignore the advice of the CPC, Chief Parliamentary Council. Let me repeat that. Chief, where we are, Parliamentary Council. And to glibly suggest there is some other version of the bill.
Madam Speaker, that bill is not before the House for debate. That is not the bill before us.
Member for Roodal Moonilal is standing on a standing order. Could you tell me what standing order, please?
Madam Speaker, standing order 48-1.
Okay. Member for St. Augustine, if I'm not mistaken, that point was already raised by the member for Oropouche East, and I also recollect that it came from the other side that this was with respect to an earlier bill. I do recollect all of that. So that is all now on the record. I ask you to move on to something else.
I disagree with that. So that...
member, you're entitled to disagree, but I have ruled. So, as I said, I understand when we're in full flight, sometimes it's difficult. All right? But you may disagree. I have ruled. Please move on.
No, but you will forgive me, Madam Speaker, when it is said that this doesn't apply to the present bill, it's my view that it does. Yeah. And therefore, whether new or old, the issues are the same. Yes. Because the Chief Parliamentary Council referenced the issue of privacy rights, and I will not be all that long. So if you just forgive me, as much painful as it might be to some who may have heard it, I do not waste people's time. His advice was on the issue of privacy rights, identical to whatever bill you want to call it. And this is what he said in relation to the privacy rights, that the bill therefore needs to be passed by a special majority, which we have, in accordance with Section 13(2) of the Constitution. It is arguable, however, that even if the bill is passed with such a special majority, it may still be unconstitutional under Section 13(1) of the Constitution, on the grounds that it is not reasonably justifiable in a society that has proper respect. This is what the Chief Parliamentary Council tells us. On the issue, forget the wording, on the issue of whether and Attorney General, I'm sure, who I have great admiration and respect for, will, when he is winding up, tell us if, yes, he may have to do things as a politician, but as a person, as a lawyer, I have great admiration and respect for him. So that the point being, does this bill interfere with privacy rights? There you go. So if it does, then the Chief Parliamentary Council's advice is germane, relevant, and on point. It goes further. Where you deal with property rights, the voiding and unenforceability of contractual rights. You have non-disclosure agreements and other contractual issues on employment. And therefore, his advice on this bill, new bill, old bill, or what, but the one I read and the one that is before us speaks to interfering with contractual rights. And therefore, once again, the great McIntyre, Chief Parliamentary Council, says, and went through a lot of detail in the law, which I will not trouble you with. He says, as indicated above, however, even if that clause is passed with a special majority, it may fail the test of being reasonably justifiable. So, you know, it is an attractive argument.
For St. Augustine, the original 30 minutes an hour. You're entitled to 15 more minutes to wind up. If you wish, you may proceed.
Less. I'm most grateful to you. So it is a very attractive argument. Let's pass the law and let's see what the courts will say. Oh, to hell. So I beg your pardon, I withdraw that. And whatever happens down the road to hell, that the court may or may not, but don't worry about that, But I thought that is what the Parliament is here for.
Yes.
Not to pass any law, kind of hop along kind of thing, and at the end of which, it's going to trip over. It is a function of this Parliament, with the government bringing a bill and the opposition trying to fix it, which we have done repeatedly. They say, no, we cannot do this because it's a fraud on the society to give them a sense that you pass law and it'll do good, but the first person who has the resources to test it will throw it down and embarrass all of us. Today is a very special day for me. It's my mother's Terrence Deyalsingh's 78th birthday, the 1st of May.
Happy birthday. Happy birthday to her.
And I too, as she moves in her age, I too. And therefore my mortality is before me. And therefore I do not wish to participate in anything that could be a fraud on the people of Trinidad and Tobago. And if it is, you see, it was just a little whisper that this thing may not be constitutional. But when the Chief Parliamentary Council tells you so on a joint select committee, to say that we're going to ignore that completely is a terrible dereliction of the duty of the Parliament. And I cannot, with all good conscience, associate myself with that. My colleagues on this side, I do not know what your position is. But in the light of what the CPC has put, I don't know if in good conscience, as much as we all may wish to have this law.
The intent.
But I want to also say, as I'm saying that, this law is not all that as necessary as you believe. Because we have in this Parliament passed law for plea bargaining. And that if it is, that information comes through whatever source and you investigate, and there are those who have done wrong, let them pay. And for those who wish to cooperate to become witnesses. But this doesn't speak about being a witness. This speaks about triggering the investigation. It's slipped in, however, somewhere along the route that if you're an accomplice or whatever, doesn't prevent you from being charged. But that the court will take into consideration the fact of your being a whistleblower, not a hot air blower, a whistleblower with real evidence. And remember where we started out. This is about what you honestly and reasonably believe and that sort of thing, which we amount to zero. But if you reach a point that matters most, where a decision is taken to prosecute, and you fall into that net, the court is required to say that they're treating you differently from co-accused because of the fact that you blew the whistle. But we already have provisions within. So take heart that there is alternative avenues to the same end. That guilty parties can participate in the prosecutorial process, not just as an accused, but as a turned witness. Like they did with Hippolyte in Dhanraj Singh, like they did with Paris in Narayan Singh. So all hope is not lost if this whistleblowing thing just goes up in hot air. It is not lost. There are alternatives, and it is defective, and I do not now have the time to go through the details. There's word somewhere about protected disclosure not being what? Prejudiced. You can't use word like prejudiced, because it is not with certainty that is required of drafting. Attorney General, I know, I'll pull out the word and send a private note to you as I have completed, that has no place in the law. We deal now with anonymous information. But you talk about anonymous disclosure when you have a whole process by which you can become protected. So you just avoid that altogether, and you slip a note or you whisper to a friend who then tells somebody, and you remain anonymous. But if you could be guilty of a criminal liability, of civil liability for slander, they will hold that information there, and if you become known, then it becomes protected. It is an awful, wiry mess that is incoherent in large parts, inconsistent with each other, because you speak about a process, first of all, for you to do your disclosure to become protected, but then you speak about anonymous, but then you can become protected if your identity is later known. Wow. Wow. This is fodder. I warn, for lawyers. This is fodder and a foolery on the people of Trinidad and Tobago. With this, I thank you very much.
Member for St. Joseph.
Oh, you finished. Thank you very much. Madam Speaker, I was very amazed by the contribution of St. Augustine this morning. But Madam Speaker, may I ask what time we are breaking for lunch, if any? So I'll know how to... 1:30, great. Madam Speaker, we have a bill before us called Legal Supplement Part C to the Trinidad and Tobago Gazette, Volume 57, number 46, 12 April 2018, number 8 of 2018. But my friends opposite cannot seem to read. They are mixing up this bill with another bill which was before a joint select. But Madam Speaker, let me say up front, I want to congratulate the Prime Minister and the Attorney General for bringing a package of legislation to combat white-collar crime. White-collar crime is the scourge of Trinidad and Tobago. It also gives rise to blue-collar crime, which manifests itself in things like murder, carjacking, and so on. This piece of legislation fits in to the suite of legislation brought by the Attorney General to deal with white-collar crime on other pieces of legislation, just for mention, civil asset forfeiture, explain your wealth bill, witness evidence, factor global forum, and beneficial ownership. Madam Speaker, it is no doubt that white-collar crime, if left unchecked, as it has been unchecked for decades in this country, because we don't have the legislative framework, and this is where the Attorney General shows his brilliance and class. White-collar crime, if not tackled, destroys the fabric of the tapestry of society. Because people feel that white-collar crime is only the remit and the preserve of politicians. It is not. It is my Honorable Prime Minister who very early in his tenure as Prime Minister said he cannot believe the level of corruption in this society. This is a corrupt society from top to bottom. And if we do not put a stop to it, it not only affects individuals, but it gets into the private sector, as it has done. It gets into the public sector, as it has done. And finally, the institutions of Trinidad and Tobago. And when institutions fail, societies will fail. Madam Speaker, I want to deal, first of all, with the statements made by the member for Oropuch East. And Madam Speaker, when we were in caucus on Monday evening, I told the caucus that somebody from the UNC is going to come here and pull the same pepper roti argument. What is the pepper roti argument? The pepper roti argument is that you will take this bill and drive it down to the hardware level and the grocery level, and just like with the pepper roti argument, you will say everybody has to spend a lot of money to set up departments. I said so in the caucus. And the link is, Oropuch West went to town saying that the hardware store, or Oropuch East, that the hardware store, and I'm quoting him, the hardware store and all the 76,000 listed businesses have to set up a unit. I predicted that in the caucus. And so said, so done. And it is not true. Because if you go to section 15 of the legislation, it speaks to an organization that has no internal procedures established or processed. They can then go to B. Although no internal disclosure has been made, where can they go? They can go to the schedule and list one of the 21 businesses there that anybody in the hardware store, in the grocery, in the pepper roti place can go to any one of these listed entities and make your disclosure. And go there. Madam Speaker, it is quite amazing how predictable the UNC is. Joint select, constitutionality will not support it. They come here, trivialize, cloud, and minimize issues. They say that no organization has the capacity to set up these units. Well, let me tell the member for Oropouche East. Tell that to Atlantic LNG. Tell that to Angostura. Tell that to BP. Right? All these organizations, tell WASA, tell the banks that they have no forum for that. But you come here and trivialize and say, tell the barraman now. Madam Speaker, I pray to God every night for the good health of Naparima. Madam Speaker, all these things are listed here. Who could set up a unit? Who doesn't have to set up a unit? So to come here and pretend that the law tackles everybody, that everybody has to set up these great, big, grand units, and the Prime Minister dealt with it. Similarly with the procurement legislation. So, Madam Speaker, that argument holds absolutely no water. Madam Speaker, if this country does not get serious with the issue of white-collar crime, we are doomed to keep repeating the mistakes that this country has made since the days of international trust. You remember international trust? Gilman Thomas Hussein? I was doing a Google for international trust because if you had a whistleblower then, depositors would not have lost their hard-earned money. I'm coming to that. I'm coming to HCU. I'm coming to all of those things. I am coming to all of those things. Madam Speaker, we must learn from our friends abroad that you need strong legislation to bring whistleblowers not into the open, but to give them a forum, to give them protection. The United States learned the hard way from the savings and loans crisis in the 1970s. That cost the US economy $150 billion because of fraud and misconduct. CLECO cost this country, what, 20 billion TT dollars? Thereabouts. And we had to recover that. International trust, amount unknown. There's an adage in white-collar crime. The best way to rob a bank is to own a bank. International trust. Hindu Credit Union, 600 million. Madam Speaker, if we do not pass this legislation today, and hearing our friends opposite, you may not get it. Because again, they are happy with the status quo. Leave it so. It's working for we. It's working for the white-collar criminals. What you want to interfere with it for? Leave it so. They want the status quo. Well, Madam Speaker, this government, under this Prime Minister, and under this Attorney General, we have a mandate given to us in 2015 not to leave it so, but to do something once and for all to treat with the scourge of white-collar crime and white-collar criminality. Madam Speaker, Madam Speaker, Madam Speaker, let's deal with some pertinent issues. Some pertinent issues. This clause, this bill, specifically talks to protecting a whistleblower from detrimental action for disclosure or wrongdoing. And that is what we have to be careful about. How do we protect persons? We give them criminal protection, civil protection, industrial protection, and political protection. Madam Speaker, another major objective of the bill is to solve what took place in the joint select. And the Honorable Attorney General mentioned Senator Wade Mark in that joint select. And Senator Wade Mark's style is well known. And all you will get in a joint select with that person is death by 1,000 cuts. I withdraw.
Yes.
I withdraw.
And, you know, like the Attorney General, you need not identify the member and deal with the issue you would like to deal
I withdraw. But it's just that when we try to go to a joint select with my friends opposite, it is clear that they want to go on a political platform in 2020 and say we can't pass no legislation. They will support no majority legislation.
48-1, this was said before. All of that about joint select.
Stop interrupting,
member, I would want to say that to me, you are bordering on improper motives, and therefore, I would ask you to stay away from that and structure your contribution differently, please.
Thank you very much. Madam Speaker, let me now turn to the contribution made by St. Augustine. St. Augustine started off his contribution by saying, and quite rightly so, that he does not know his future in the electoral political arena. Well, if ever there was an admission, there is. Even your own political leader in the COP is saying that. But St. Augustine talked about cause of death. He mentioned death. Madam Speaker, if there was a whistleblower under the UNC, the death of that PTSC employee who was murdered in his bed because of his association with live sport may not have happened. If there was a whistleblower,
member, I'd ask you to not go that way, to withdraw that and put it in another way, please.
Madam Speaker, the member for St. Augustine said that one of his constituents was murdered in a car a couple days ago.
No, he did not.
3 people.
It was my constituent, not his constituent.
He said it was your constituent. I was simply responding.
We all know the standing orders. If somebody has an objection to raise, there's a certain way that you make an interruption. Member for St.
Thank you. So, Madam Speaker, all I was doing was responding to St. Augustine, where he rose the specter of murder of people who are the constituents of Oropouche East in a recent incident. All I am saying, that whistleblowing is important not only for white-collar crime, but also for the annex to it, which is murder. And all I am saying, the incident of live sport, if we could a member of parliament and the minister lost his job over live sport. And if there was a whistleblower then to tell the country what was going on, maybe that person from PTSC could be alive today. That's the only point I'm making, and I move on. I move on. St. Augustine said, it's a difficult culture to change culture. Those were his words. And that is what I'm saying. If we don't change the status quo, if we are happy with the status quo, St. Augustine, then what are we doing? What are we doing? But this is an opportunity, St. Augustine, for us to come together and change the status quo and join us in changing the status quo. In Bill number 8, 2018, join hands with us. Why is the UNC always comfortable with the status quo? Why? Whether it's anti-gang, whether it's explain your wealth, whether it's registration of deeds, whether it's beneficial ownership, leave it so. Consult more. Go to a joint select. Talk here, talk there. Don't pass nothing.
Hey, please.
He started up and doing this.
Member for St. Joseph, please continue.
Thank you very much, Madam Speaker. Madam Speaker, the status quo is what has Trinidad and Tobago where it is. And we have a sworn duty to change the status quo. We are not going to leave it so. And we ask you, we ask the UNC, we ask the Congress of the People to join us today. We are just 2 swords length away. Forget the sword lengths. Arm lengths. Join us arm in arm, hand in hand, to send a message to Trinidad and Tobago that 41 good souls are here today to serve your interest and to battle the scourge of white-collar crime once and for all. Join us hand in hand, mano a mano, woman to woman, whatever. Let us do that and send a message to the country that you have elected 41 people of integrity.
Member for St. Joseph, please continue.
Thank you very much, Madam Speaker. Madam Speaker, the member for St. Augustine incorrectly attributed a statement to the Honorable Prime Minister. He said it was the Honorable Prime Minister who said that professionals have failed this country. The Prime Minister has repeated that, but it was actually former President and Prime Minister Arthur Napoleon Robinson, I think, who coined that phrase, that professionals have failed this country. And today, I want to put it to this nation that the member for St. Augustine, as a professional, needs to reflect on that himself by trying to bring Section 137 of the Constitution into this debate where it had no right to be.
Did not allow that then, member for St. Joseph, and I'm not allowing it now.
Thank you very much, Madam Speaker. He has also failed this country in referring to the letter given by Ian McIntyre for the old piece of legislation, and he went to town on that. Madam Speaker, Section 13 of the Constitution, Part 4 of the Constitution, exceptions for certain legislation, and may I read it in so I could deal with the issue. Section 13(1). An act to which this section applies may expressly declare that it shall have effect even though inconsistent with Sections 4 and 5, certain rights. And if any act does so declare, it shall have effect accordingly unless the act is shown not to be reasonable, justifiable in a society that has proper respect for rights and freedoms of the individual. Madam Speaker, that is why this legislation is a special majority. The Constitution provides for all 41 people of integrity, representing 1.3 million people under Section 13, to offend Section 4 and 5 rights. That is why we are here today, reaching out to St. Augustine, reaching out to Oropouche East, and most importantly, reaching out to Siparia. Yes, we know the bill offends Section 4 and 5, but Section 13, on justifiable grounds, it is justifiable that you bring this piece of legislation for all the reasons we have articulated, that white-collar crime and white-collar criminality is the most important issue affecting Trinidad and Tobago today, last year, the year before, the last 5 years, the last 10 years, and the last 20 years. For decades, Madam Speaker, white-collar crime is the issue. So is it arguable it is justifiable? We on this side certainly feel so. And the place to have that aired will be in the courts of law. Let the courts of law decide on that. But let us pass the legislation. I make a clarion call to the 18 seats opposite. A clarion call to my colleagues opposite to join with the 23 across
Madam
here.
Speaker, 55(1)B, I think the Honourable Prime Minister asked the same thing. St. Joseph repeating this thing continuously.
Okay, so member for St. Joseph, I would ask you to move on to...
Thank you. Thank you very much, Madam Speaker. So finally, let us join hands together in bringing this piece of legislation. Madam Speaker, as we come close to the lunch break, this piece of legislation is a line in the sand today. Today, which is the 1st of May, May Day. Congratulations to the labor movement. The 1st of May today is where we put a line in the sand and say we have a piece of legislation which we could build on for the future. And I will explain what I mean by that. Madam Speaker, many countries in attacking the issue of whistleblowing don't only have one piece of legislation. Whether it's England, Canada, the United States, Australia, they always start off with a piece, and then as they get the experience operationalizing, they will bring on other pieces of legislation.
It is now 1:30. I take it we should take the suspension for lunch now. We shall resume in an hour's time at 2:30.